Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people he spelled P-E-O-O-P-O-N. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
She got more. We need to see. Because he's the guy.
Welcome back. Welcome to the Court of Public Opinion. I am the Recovery Addict. This is a long time coming. It's a long time coming. We hopefully this afternoon, not immediately. We're almost done with jury selection. Almost done. There's a little bit of paperwork. It's almost all that's left. We are about to begin the trial with Sarah Boone. Oh my goodness. Podcast tonight? Yes. Yes. That's a big yes. We'll have the podcast tonight. Thomas will be back. It's going to be awesome. A big shout out to Zimmy. First in chat today. Zimmy, congratulations. Zimmy, you've won before and now you've won again. This is going to go on your permanent record. The music is kind of loud, but I needed it. It's been a rough lunch. I have not eaten. Well, I ate 2 of Mrs. R.A.'s chocolates, and that's it. I did everything from disassemble my furnace successfully, attempt to fix it.
If they didn't, I would lose my mind.
Unsuccessfully. Do rough maintenance on my chainsaw successfully. Start that successfully. And then called a heating and air conditioning guy who's going to be here any minute now to come fix my heater because 60 degrees in the house is just no bueno. No bueno. It needs to be warmer. I shouldn't have to get in the fridge to warm up. That's where it's at. But it's been a rough lunch. So if it looks like I just ran a marathon and I'm sweating to death, it's because I did. And I had my best ever time. Do not use the chainsaw in the furnace. It was about to come to that, Kelly Mae. It was so close. It was so close. Oh my goodness. We have about 10 minutes. Oh, we've got somebody calling. Hang on one second. Hello, this is R.A. Oh, sorry.
Debbie Cook.
Debbie, this is R.A. How are you doing? You're live on the air.
Hey, I'm doing good.
Yeah.
Okay. Donnie wants me to tell you that he sent you a video that somebody scammed him. And I promised him I would tell you, and I would keep my promises, so I'm telling you.
Thank you. I saw your text, and I saw his, and I have no idea what the video is. It's some guy at a doorbell with the doorbell ringing.
I don't know. I'm just keeping my promise.
All right. Thank you. All right, Donnie.
Okay. All right. Bye.
Bye. Donnie, no clue. No clue. I watched it like 6 times. I'm like, that's a ring doorbell. Someone's at your door.
Bring the jury.
Let's see.
I saw a chicken fight.
All right, cool stuff. All right, let's see. AKA the cat lady. Do you believe that Sarah and the defense genuinely didn't understand what she did to be charged with second-degree murder? No, but I think they would like to know the exact theory of the prosecution.
Scratch all that.
Because the theory might have specifics in it that they can attack.
Somebody just sent me a video of roaches fighting.
I don't know who won. The theory of the prosecution is different. That's what they say. We believe that some honor about this date. She did this, and this is the moment where she committed the crime, and this is why she's guilty. That theory is how they built the pieces together, and that's something that's easier to attack than just the general. We've charged her with second-degree murder. So. The soundboard was going nuts. I've turned it down. But they want the state to sort of spell it out a little better because they're going to do it in the open. The state's going to lay it all out for the jury and say we're going to show you, and they're going to step by step through what they say they're going to prove, and that's what the defense says they want. Now, do they already know this? Probably, but they want to hear it so they can. Because it locks once the state comes out with that and says, "Here's our story," it sort of locks them to that scenario. And if there's a piece if there's a piece that the defense could say, oh, I didn't realize they were going to talk about, the wine bottle receipt, because we have something that we might be able to investigate to say that that's actually not valid. If we can chip away at like a chunk of their story, then it shows that they might have it wrong. So it's all about casting doubt. And it's about, who shows the cards first. It's like in a bidding war. When you go to buy a used car, the first person to name a price loses. Okay, that's what's happening in court here. And unfortunately, in this case, Sarah Boone named her price. And so she might be losing this round, this court, this trial. But, all right, what are we going to count for this one? I don't know what we're going to count yet. I've just been listening to what's going on first, like before all the pretrial stuff. It might be tempting to do something along the lines of times that the judge basically corrects the defense and says that's not how it works. That's not how it works. It's a nice idea. I'm glad you like that, but that's not what we're doing here. So, all right. Quick check. Here we go. This one off. This one up. Trying to get everything straightened out with the feed, which is not live yet. We'll have that as soon as it is. Big shout out to Trial TV Live, who's been instrumental in a big way in making that happen. Okay. Looking for... Sorry, I've got to scroll through a couple things here. Okay. All right. Let's see. We welcomed the new Zimmy was our internet owner. We're good to go that way. Let me log back into the live view. It's good to go there. Let me check my text here. I have to text really quickly. Is this ASMR too much for you? All right. Okay. Did you get the piece of hardware to Orlando? Yes, it's down there. We're connected to it live. There's just no stream from court yet, which is all we're waiting for. As soon as that does come in, we'll bring it to you. What video is that? Why is that showing? All right. I'm impressed by the texting speed. I'm all thumbs when it comes to texting. I'm pretty good at that. Objections counter. That I think it will be. This one will be spicy. Georgia did not have many objections. If we go back to just plain objections, I think that would be a good option. Okay, my heater guy is going to text me when he arrives. That's great. Jules is there. Awesome. Jules is reporting for us down there today, which is great. Ready for the Gray show. It's going to be a little weird. I think the whole spicy counter, this one's going to have a lot of spice, and you're going to see some tension between the prosecution and Mr. Owens. Mr. J and Mr. Owens probably never shared a lunch, where if they have, they probably never will again. AKA the cat lady says, how about George's fingers coming out as the overt act? The overt act has to be when the moment of intent was put into play. And I think the overt act was her going upstairs. I think that's what the state's going to say. You can also make an argument that her failing to act when she was informed that she had put somebody in a situation that was possible, that a reasonable person would consider life-threatening or dangerous, that could also be be that moment. So it'll be interesting to hear what they come up with. All right. Brandy Churchwell is there. I know at some point Peter Tragos is going to be there. What about the counter being when Sarah speaks up out of turn? Sinbad, I'd be surprised if that happens. I think you're going to see her throughout this trial, especially at the beginning, or especially if things are going badly, engaging in an animated way with her lawyers, probably more so than we've seen in many, many trials, because she really wants to be a part of that defense and be participating actively, informed, and a decision maker in that defense. The lawyers, not so much. STS is there. Joel is there. Lawyer Lee is there. It's a who's who in the audience. It's awesome. Hopefully we'll see. We need a law tuber sighting counter. There's going to be somebody in every shot, except for if we're looking at the judge. There's going to be somebody in every shot. Do they have a jury? They should be very, very close if they haven't picked them all together. I think they're really close. Oh, Lawyer Lee is Delphi. Lawyer Lee is Delphi. That's a tough trial. Man, that is a tough trial to sit through. I mean, every trial where there's a loss of life, it can be really, really difficult. But Delphi is just next level. Judy M. Love RA, all the addicts in this happy place. My news buddy said the Orange County Courthouse fixed all their IT issues just for this trial broadcast. They called the Geek Squad and said, "Come down here and fix our cables." Yeah. They're working on jury selection this afternoon. The judge says we should possibly have openings. So it's going to be business and then hopefully the business. Not show business, the business afterwards. Squinty Bubbles, thank you for the super sticker. Love having you here. As soon as we get a feed, let's see. We will bring you that feed. So just 1 second. Chris is literally hovering at the media portal, or the media. What do they call it? The media pedestal is the word they use down there in Florida. Waiting for the image to pop up on the screen so he can text me and say, "Now hit the button." So we'll have it for you the moment it's available. Got solid connection, full power. Everything's set up. Stream is live. We're good. Why am I nervous? I don't know. I always get nervous before a show starts. Squinty Bubbles, I saw that your donation was in pounds. Thank you for joining us from across the pond. Thank you. Shadow gifted a membership. That one went to Marianne R. Congratulations, Marianne. You're here just in time. We're getting warmed up. This is the warm-up for the Sarah Boone trial, which is about to begin. Snacks were denied. You know what, Eddie? What Jules told us the other day is Sarah Boone was given 2 glasses of water but no snacks, and she dumped one. She spilled it all over the desk. But people in the courtroom, like observers, are not even allowed to bring a water bottle with a lid on it. So there's that. So no snacks, apparently. Snacks are out. No snack for you. It's like the soup. No, never mind. I'm also really excited, if you can't tell. This trial is an interesting trial, mostly because usually when a defendant gives what could be considered a full confession on video, and doesn't dispute the facts of the case in that, who did what, we see a guilty plea. And Sarah Boone has not done that. She has basically agreed that everything, the events happened as they roughly occurred. I mean, the state's not coming out saying she drugged him. I don't think they're coming out saying she drugged him and dragged him into the suitcase. Well, he couldn't fight back. They're not saying that. I think it was a game. I think she did. I think there was some alcohol involved and it was goofing around. And I think it went too far, far too far. But it's going to be interesting to see how she carries her, but it wasn't intentional, argument, which is what she said originally, and how she mixes that with it was a battered spouse. So, basically a self-defense type claim, which will require her to take the stand. So there's no question at this point, zero question in anyone's mind. She is taking the stand. She has to use the defense that she has said she's using. She can't do that unless she asserts that certain things happened that would put this case or this relationship in a situation where some sort of self-defense, a battered spouse type self-defense, would be legitimate, would be the next step or be a reasonable conclusion, which means she's going to have to tell the story again, and it's going to have different facts than the judge has heard already, because so far he has not heard that. And that's why he sided with the prosecution on their motion in limine to not allow any experts to testify or anyone to testify to that until that threshold has been met. So you're going to hear it in the opening statements. Lawyers can talk about it there. But then in the testimony itself, until Sarah Boone takes the stand, which will most likely be on the defense part, you're not going to hear battered spouse anything. All right. Where's this case being tried at? This is in Orange County, Florida, Angelique. This is Ninth Circuit. I think it's Ninth Circuit. And we're on, I believe, the 12th floor of that courthouse. I think we're in courtroom 12A today. Well, let's see if we can get everything working here. Still no feed. It's supposed to start at 1, but nothing is showing up yet. See this the video. I'm not see who's Dallas. Thank you. Talking about the video, this is probably going to be the most disturbing and difficult to watch portion of this trial. That is because during the commission of this crime, and I mean during it, Sarah Boone used her cell phone and filmed the suitcase that George was in, and there's audio and video, and I believe also a still image taken during that time of the suitcase being on the ground, on the floor, with George inside. You can see the suitcase move. It's pretty apparent there is someone in there, and you can hear George begging Sarah to let him out because he can't breathe. And you hear Sarah's response. And Sarah's response, the first thing you're going to notice when you hear that is that her voice, to me at least, sounds slurred, which would indicate the presence of alcohol. This is something that she said she wasn't drunk. She wasn't drunk. Did I say Orlando? I said Orange County, right? It's Orange County. It's tried in Orlando. She says she wasn't drunk, but it sounds like she was. There's going to be evidence that's brought in that shows that there were, I believe, multiple bottles of wine in the garbage, as well as a receipt showing a purchase of wine for one of those bottles, just like during that evening, like they went out and got more wine. And so there's a ton of evidence. As far as that goes, this is not a whodunit in any way. Nothing at all like the Georgia trial with Melody Ferris. As a matter of fact, the defense will probably stipulate to many, many facts in this case because they just don't disagree with that. But so we'll see where we go from there. All right, I'm a little bit distracted because we've got to get the feed running up, and there's some buttons I have to push on my end to make that happen. So I'm watching for texts. The court's a little late starting again, which they've been doing a lot. Okay. All right. So this pretrial stuff and jury selection should wrap up, and then we should have opening statements by this evening, which is our hope here. Just check a few other places. right, what's I've been ignoring chat. Sorry. Fun for a can of Raid says by me. Do I need Raid? The only roach in my studio is the 3D printed one that was sent to me last time we had one in here. That's the same week that Peter Tragos had one in his studio. I don't know what it was. That was a bad week for YouTubers, I guess. Okay, judge says a minimum of 22 years if she gets guilty, maybe 27, I forget. This is an interesting fact, Justin, because Sarah Boone, at the last minute, I think this was last week, was offered it might have been a little over a week ago, was offered a plea deal where she would plead guilty and she would get, I think, a 15-year sentence, which would, because of time served, because she's already done several years, she's less than 10 years is what they would say. We're saying less than 10 years in. Now, 10 years is a long time. 1 year is a long time to serve in jail. I'm not minimizing that. Jail sucks. If you don't want to be there, jail is probably the last place you do want to be. That didn't make sense, but you understand what I'm saying. Jail sucks, and any time there is bad. But when you're facing as much time as she's facing, I think that plea deal, being out in 6, as Genjo says, that's looking pretty sweet, especially when you have such a difficult fact pattern to deal with. Your own confession, videos, inconsistencies in your sworn statement to law enforcement, inconsistencies over, on the stand. She's going to have to tell a different story than we heard from her when she took the stand in the pre-trial hearing. Anyway, no snacks in the courtroom at all. No snacks. All right. She wanted the world to see her on TV. I don't think she does. She's got a little bit of disdain for the cameras. I think she recognizes the importance of them in her getting help, because she honestly would not have an attorney if it weren't for the cameras that have been focused on her case. So, Judge was in a mood this morning. He wasn't happy, and I don't blame him.
Call from
Mr. Intentional.
Ivan, how are you doing, my friend?
Hey, how's everybody doing? Long time no talk.
Yeah, it's been a bit. Are you gearing up for Sarah Boone? I know you've already ready to vote. You're ready to vote on this one. If you were on the jury, you'd like hand me that ballot. I'll fill it out for y'all.
How excited are you? Like, this has been like the ultimate anticipation finally coming to a crescendo, right?
It's sort of surreal in that it's always been something off in the future, something 6 months out, something next year. And in a way, I feel, and I've told you this, I feel really bad for Sarah Boone. I don't like the idea that someone can get charged with a crime and sit there for years in court.
Yeah.
Charged, not convicted, charged with a crime. I don't like that. Now, I realize she caused a lot of this. She was a little bit of a difficult customer when it came to a lawyer-client relationship. But
at some point, the court needs to protect the defendant from themselves, I think. And I don't think that was done necessarily, even though she was in full self-sabotage mode, whether she realized it or not. But I didn't realize that deal had been offered. Boy, she's going to be kicking herself in her cell. When I did my time, there were guys that I sat with that were offered plea deals that turned them down to take it all the way. And of course they lost. And let me tell you something, that day that they were supposed to get out, they all remembered that date. Okay. Cause that day would come on the calendar when they could have been out for their, plea bargain that they refused. Mm-hmm. And that is a somber day, for those poor SOBs, because
every day after that is
oh like, man. Yeah.
It's like serving, it's like serving 2 days in one.
It's like a gut punch. It just when you think they can't take anything else from you, they find a way to, figure out a way to take something else. And that day is almost worse for guys than your first day in, because that one's totally on you. that one is, you can't blame anybody else but yourself for that letdown. And she's going to have that day. And it's, like you said, because, she's got 4 or 5 years in, she gets some kind of good time while she's there. Although I don't know if Sarah's going to.
I'm not sure if she can do that. Yeah. She's had a rough go of it. She really has not made a lot of friends with corrections officers there. Although there are a couple she likes.
Yeah, but your behavior in the county jail won't none of those demerits, none of those instances will count when she gets to the state level. All this,
she's being held in the prison.
Right.
Even though
she's still a county inmate until she's still a county inmate until she's convicted.
So they're going to wipe the slate clean and give her a new chalkboard for demerits.
100%. Yep. As soon as she's a state inmate, she'll go into the prison system, even though she's already in the prison system. She will go in, she will get her formal DOC number, and she will arrive, even though she's arrived already. She will begin her sentence as a state inmate as clean as the guy who comes off the bus. Yes. But nevertheless, her behavior doesn't indicate any sort of indication that she's going to start towing the line when she's sentenced. In fact, at that point, I suspect her behavior will become worse because she has nothing left to, this is her swan song. This is what her story has all come to a head for, and she's going to relish it and live it up. And I am afraid for her, she's going to make herself look like a fool, even though I don't believe she is totally a fool. I think she's going to sort of end up taking the fool's, route throughout this process as it gets, more and more writing on the wall that she's not going to win.
That being said, though, there's something to be said about your right for a day in your court. You have the right to go to court and force the prosecutor to present evidence and prove the case against you. That is a right every single person has. Sometimes we look at this as like, why is she going to court over this? Why in the world would she be, fighting this battle? Clearly she's guilty, some people are saying. Clearly she's guilty. It's obvious. I mean, we've got the video, her voice, she filmed it. And I realize that's a high bar. But I
think at this point, this might be one of those cases where the jury instructions and the interpretation of the actual statute is what her only hope is, that there's one juror that somehow understands the definition of whatever specific charge she's convicted of is not exactly what that game constituted, that they were playing. I think that's the only hope she has, is some weird sort of interpretation that one juror may have, that, because what's the actual charge?
Second degree
murder.
Mm-hmm.
Yeah, and so it makes you wonder, and I think, without that video, this would be a whole different ballgame, RNA. That video, I don't think you can charge murder without that video, but that video sort of proves intent in my opinion, where she's sort of, mocking him and saying, this is what you did. This
Save your breath. That's how I feel when you choke me. Yeah.
Without that video, it's probably manslaughter, and so I think the only hope she has is that a juror somehow interprets, her behavior is more manslaughterous, but then again, lesser included come all the time, so let's not rule that out either. I think that's a possibility down the road.
Yeah.
But do we have a witness list? Who's calling?
It's filed. I haven't gone over it. I think our mods have it for spelling of titles and things like that. Here's a question for you, Ivan. Knowing what we all know, can we set that aside? Say if the judge turned to us and said, "Look, we're short one juror." Think of this for you personally, and regardless of where you're at. Judge Kranick turns to you and says, "We're short one juror, and I need you to step up and do your civic duty." Can you set aside anything you've heard about this case and be fair and impartial and try this case with a just verdict?
Me? No. I can't, because of the amount that I delved into this whole sort of arena, but I don't know. I don't know that I could, because I've already seen the video. I've already, worked all the, it's our understanding that the jurors haven't seen this video. The first time they're going to see it is in court, right? Obviously.
Yeah.
That's the yeah.
I would guess that somebody who's followed the case closely is probably going to be excluded from this jury.
Yeah. I mean, you would have to think that down wherever she's from in Florida, this has been wall to wall. Maybe not for the last 4 years, because it's a long time in our 24-hour news cycle. But I would think now that this is actually coming to a head, this is going to be lead story on every local news channel. And I imagine it was difficult to find a jury, but then again, maybe not, because these two people had a rough life. They weren't exactly pillars of their community. They were just sort of, the forgotten kind of class of people that don't really have a name for themselves until it's a bad name, and so, maybe it wasn't all that difficult, but I think that it's going to be very difficult to find a jury of her peers. I don't know that she has many peers. And so I feel as if she's going to have the deck against her from the beginning, but all of this is of her own doing. And that's where it becomes difficult, because I too had empathy for her being somebody who's, been in a county jail for all that time. There's nothing to do in that jail. And RA, I think you're mistaken on cases. She hasn't been in prison. She's been in the Orange County jail this entire time. That's been part of the problem, where she doesn't have access to resources, and she doesn't have access to, activities to keep her mind at, working like you do in prison.
I thought she was in a prison. I thought they held her in a prison.
Nope. I think you're mixing up cases here, because she's been in that county jail.
I'll have to go back and look at her letters, because her address was on there, and I was fairly certain it was.
Yeah.
She's
I'm
in
pretty
jail.
sure it's Orange County jail.
I thought for some reason they moved her there. Okay, I'm wrong on that one. I apologize. All right, we're trying to get the feed up on the screen here right now. We're just connecting things as we speak.
No problem. I'll let you fly. I love you guys.
Yeah, sounds great. Yep. All right, we're just trying to get it connecting here, if it will. I'm seeing it, if it will load. Give me a second here. Says I have an excellent connection. Waiting for the feed to come in. Okay, there it is. All right, and on video 7. Sorry, guys. Got to get this right. See the feed on top mark. And let's get it right here. There it is. All right. Now, took a while to get here. There we go. Give me a second to get this right. All right. Zimmy, thanks for getting that fixed there. We're waiting for sounds to come in. It's not in there yet. I'll be adjusting it a little bit on my end. Court has had trouble with mics this morning. It's been a little rough. The lawyers have not been.
All right, thank you, counsels. Defense counsel, if you could see to address those matters that we discussed, I would appreciate it. Anything else we need to address before we bring in our panel?
No, sir.
Defense. No. All right, let's stand and bring in our panel. Thank you.
I like that he says, let's stand.
Defense counsel, if you could see to address those matters that we discussed, I would appreciate it. Anything else we need to address before we bring in our panel?
No, sir.
Defense.
Sorry, I had a double audio.
All right, let's stand and bring in our panel. Thank you.
But that's some great ASMR of crushing some paper, tearing something off the notepad. So you just heard the delay. The first time you heard that, that's when I hear it. I see it straight from court through the live view. The second time is when it plays out on Top Mark Media. It's a unlisted feed that is then being played here on this channel. So that's how it works. That's the tech side of it. Have not seen the people in the courtroom yet. We'll see what the camera shows us.
Shelby, hand me my seating chart, would you?
Hand me my seating chart, would you?
Thank you.
We have heard that she's had some moments of disagreement with her lawyers. It's been a little bit tense, some animated discussions. Ellie, thank you for reminding people to hit the like button. That helps the channel a ton. If you can do that, it is free today only. We ask that you either hit the like button once or 3 times. 2 is no good. 2 is no good. Don't hit it.
State, do you recognize our panel?
As best as possible.
Defense, do you recognize our panel?
Yes, Your Honor.
All right, thank you all. You all can be seated. Members of the jury, thank you again for your time. Welcome again to 23 Alpha of the Orange County Courthouse. My name is Judge Michael Kranick, and again, I will be the presiding judge in the case of the state of Florida versus Sarah Boone. I am going to ask the state to introduce themselves again to you this afternoon.
Good afternoon. Dave Cacciatore, Assistant State Attorney.
William J., Assistant State Attorney.
And defense, if you could introduce yourself and your client, please.
I'm James Owens, and I represent Sarah Boone.
Tony Henderson, representing Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Shelby Andrews, Jury Selection and Trial Consultant.
Lauren Henderson, assisting the defense.
Thank you all. You can be seated. Now, members of the jury, yesterday evening around 5:15, I gave you an instruction. If you could please raise your paddles to show that you complied with the court's instructions in this case. Record will reflect all paddles have been raised. Now, members of the jury, I want to take a moment again to thank you. Yes, sir. Juror number 26. Juror number 39. Did you follow the court's instructions?
I was able to hear this yesterday.
By you were able to hear the news yesterday, what does that mean?
I'm sorry. She needs a
Can we get her a microphone, please, for Madam Court Reporter?
Yes,
Thank
please.
you. Juror number 8, I appreciate you. Yes, ma'am.
I was at my parents' house yesterday evening, and they keep the news on, and I was in the other room, and I overheard it.
Okay. Did you overhear anything pertaining to this case?
Yes, I did.
Okay. Can the parties approach for a moment? Actually, just hold that thought. Ma'am, just hang on for me. We may have some follow-up with you individually. First, I want to take a moment and say thank you for your patience. I know I said we would start at 10 a.m. this morning, but one of those unscheduled breaks came up between counsel and I that you could not participate in. It took us some time to work through that, so I thank you again for your patience as we resolve those issues this morning. I want to confirm with all of you before I turn over questioning to the defense. As each and every one of you sit here today, are you an Orange County resident? Raise your paddles if that does not apply to you. Okay. Juror number 45. Yes, sir.
I recently moved to Seminole County, but I haven't registered.
He used to live there.
When did you move to Seminole County?
My lease began August 1st.
Okay, but are you still a registered voter here in Orange County?
Yes.
Okay. Can the parties approach for a moment?
I love they're using the paddles here. Parties are approaching. There's Sarah Boone. They're going to talk this over. Okay, so we have one juror, and we heard I believe it was defense also say and juror 35, which means there might have been a second juror who possibly didn't raise the paddle. But we definitely did hear that one of the jurors said, "Excuse me, Judge, she didn't raise her paddle," and that's what started this whole thing. She's like, "Yeah, I listened to the news." This is wild. This is a wild start already. Okay, there's a loud stereo shaking my whole house. When I grow up, I want to be that cool and have a loud stereo and drive it in people's residential neighborhoods. That will just be great. Okay. Is this the final jury? Virginia, no. We're trying to get the final jury. The final jury is going to happen really quickly, I think. This is still a panel. Well, hold that thought. It might be the final jury. They only need 6. The judge said he wanted 6 jurors to sit on it because it's not a death penalty case. So in Florida, you get 6 jurors, but he wanted 8 alternates. That means most of the jurors who sit through this trial, if we don't lose any alternates, would not be deliberating. He called them the jury. We might lose an alternate today. Think this is the final jury? I'm messing with the audio as best I can to get the sound as good as you can for you. I was wrong. I said we were going to be in 12A. It looks like we're still in the larger courtroom upstairs, which is on floor 23. So this is not going to be the courtroom where the trial is going to be held, unless he's booked it for the rest of the day. I think we're moving back to 12A at some point. They're 14 in the box. They don't notice at this point whether they're jurors or alternates. I think anyone who understands the jury system in Florida understands that there are going to be 6 deliberating jurors. But most jurors, statistically, most jurors have never been a juror before. It's the defense's turn to question all potential jurors. And we're hoping we get good audio, that we're able to hear everything. Defense still has about 2 hours of questioning, and then the judge expects. Feeds flipping out a little bit. The courtroom says they upgraded all their equipment for this, but we still got little drops here and there. Let me just check on my end. Yeah, we're showing 10,865 kilobytes per second. We've got a solid feed with bonded cellular. So if it drops out, that's not on our end. Sarah's busy. She has been all along. She's been taking notes. There was one point 2 days ago, I think it was, where she wrote a note and handed it to the lawyer, and the lawyer crumpled it up. I'm not sure if he read it first or what, but he was like, "Nope, not happening." Don't think anyone's hacking the Top Mark feed. We're not listing that one publicly. A clean feed without my commentary would be available through Trial TV Live, who we've partnered with on this one. Magistra, they have not shown who's in the courtroom yet. We'll wait and we'll hear from Jules. She is there, and she'll get to give us an update. Will spankings be involved? I think I'm about to catch a whooping. No, the paddles are. I think the paddles are. They're not the ones I have. First of all, The paddles they have would probably be juror number paddles, a lot like bidding paddles, where you have your bidder number. It would be like that. The yellow is due to the color balance in court. Probably color balance last in the other courtroom, and the walls are different. Okay, we should have audio back in just a moment because it looks like the conference is over. They keep walking back and forth. In Georgia, the defendant has the right to participate in all meaningful portions of the trial.
Members of the jury, again, thank you for your patience. We're going to take a short break at this time. Don't go far, 5 minutes, just outside. And if jurors in seats 39 and 45 could stay behind. The rest of you, same instruction I've given you the last couple of days. There's still no case. Do not discuss this case. Don't do any independent research or investigation. And don't talk to yourselves about the case. You can talk about anything else other than those things.
Don't talk to yourself about the case. All right. It looks like they might have... the feed from the courtroom is a little rough. Don't talk to yourself about the case. Don't even think about it in your head with yourself.
Thank you. Y'all can be seated.
We need a y'all counter, maybe. How many y'alls do we have so far?
You're good. Thank you, sir. Appreciate you. All right. Jurors in seats 39 and 45, thank you so much. In speaking with counsel for both state and the defense, we're going to go ahead and discharge you from your jury service at this time. Please report back to the first floor, jury services. They'll validate your parking and give you any additional instructions. And again, I thank you for your time and your sacrifice during this week. Enjoy the rest of your week. And thank you again.
Enjoy the next month. Enjoy your month off. They're out. They're not taking any chances. She heard a little bit of the news, and without even knowing what she had said, without even knowing like what they'd heard, that was enough. They said we don't want to risk it, and that's probably a for cause. That's not one of their strikes.
As addressed at sidebar, jurors in seat 45 wearing badge 240 has been stricken for cause by way of stipulation, and juror in seat 39 wearing badge 551 have been stricken for cause by stipulation. One other additional matter, juror in seat 51 had advised either yesterday that did you recognize anyone? She had advised that there was a law student that she recognized she had seen at some volunteer organization. She's in fact Judge Leach's intern sitting in the box. And ma'am, if you please could introduce yourself for the record.
Yes, for just 30 minutes.
Okay. So she is not a member of our panel. So I just wanted to put that on the record as to who it is that she may have noticed, and that person is not a member of our panel. All right, we'll be in a short recess until our panel comes up.
At some point, you were going to talk to Ms. Boone about the lawyers, some being out at the time?
Yes, okay. Ms. Boone, one of the matters that we addressed at sidebar out of everyone hearing is that I've noticed that one of your lawyers has been in and out of the room and sometimes been waiting, or this morning I asked you if you were prepared without your attorney being present. You said yes. Your lawyers have advised me that due to scheduling and speaking with other witnesses as to coordination, not all of your lawyers may be here all at the same time. It may be Mr. Owens, maybe Mr. Henderson, It may be a combination or less than that much.
She wants
so the
full
question
attention.
I have for you, ma'am, are you on board with proceeding without your full defense team being present at all times?
I am.
Okay. Any further inquiry state as to that issue?
No, Your Honor.
Any further inquiries to that issue, Mr. Owens?
No, sir.
Okay, thank you all very much. We'll give the juror another 2-3 minutes, and then we can have the deputy bring them back in. Thank you.
Wow. So why did I believe that was Mr. Owens who raised that with the judge, saying, I believe you were going to tell Sarah Boone that we can leave. We can, one of us can leave for a little bit, and that doesn't mean we're not paying attention to our case.
Try again, sir.
Can you hear me?
Yes.
That works? Yes. Okay, we're good. Thank you.
Good? Okay.
Unsolicited advice?
Yes.
The tie, I think, works better because when it's on your lapel, it's very directional when you turn your head. That's all.
Oh, really?
Judge giving tech advice on placement of the lapel mic.
It's that close, you can hear me.
Okay, so now we'll be back with them in just a second as they have a little bit of a break, and we'll be back with the stream as soon as they come back. All right, Random Pie, thank you very much for
Move my whole body. So keep my head still.
It's a hot mic. Thank you very much for the super sticker. Appreciate the support.
This is the third one.
It might be a problem with the connection out of that 23rd floor. Don't think we had problems with the signal dropping out at all. Out of the 12A. Jessica Hicks, enough time for a baby. 9 months. Congratulations. Love that you're here with us. You can never leave, of course. But thank you. Wouldn't be the same without you here. There is a link for the thumbnail. Red Pen is heading up the design of that. I think we've got quite a few people participating in there. And if too many people, it gets a little crazy. But we're up and running on that front. Let's see. Need paddles on the thumbnail. Ashley, I missed your milestone message. I'm sorry. It was probably like 1,000 months, wasn't it, Ashley? Pretty sure it was 1,000 months. Thank you, Ashley. Ashley's actually one of our moderators on the Top Mark Media channel. Appreciate her work. Hot Mike was on my bingo card. Zimmy, you're already pulling ahead from the pack. 16 months. You're close. It's close to 1,000. You're almost there. Thank you, Ashley. Appreciate that. Ivan, you missed your invite to become a mod. Maybe check my trash folder. Ivan, I can't make you a mod. Mods get muzzled. You know how that works. Mods can't talk very much. And we like hearing from you. Kirian Baines, welcome to the gallery. Love the Green Courthouse by your name. I think that's at least month 3. Betsy Jean, member for 7 months. Woohoo! 7 months, Betsy. Thank you. And Lee, one of our OGs, Lee and Shells, both of them, a member for 20 months. Boone trial. Yay. Yay. Ivan, it's in the mail, says Weatherwatch. He's got you covered. The invite's in the mail. Lee was one of our court watchers as well. Lee, I don't remember which court you went to for us. You've been to a couple. I know you've been to. You were up at Karen Reed for part of that. Remind me. Lanny for Liberty, welcome to the gallery. Thank you very much, Lanny. Mods get muzzled. It's like a slogan. We don't publicize it. And the reason being is when a moderator speaks, their text shows up in blue, and it basically represents the channel. And I love that moderators can share stuff. Wow, this feed from the courtroom is terrible. I'm showing. It's awesome. I'm seeing no dropped frames or anything from the live view, but the feed into the live view from the court is not good. Maybe tomorrow we'll use a different connector. Lady Tammy says, you need to put on your Sarah Boone shirt for opening statements. Hang on, I've got it right here. The Sarah Boone shirt.
3, State of Florida versus Sarah Boone. State.
Steve Getchcore on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone still seated at counsel's table. We're bringing our jury back in. Let's all stand, and we'll turn over the questioning to you, Mr. Henderson. Nita was working it up. Let me text her right now.
Lawyers are conferring with her. This is the chance the defense gets to ask lawyers of the potential jury. This is the first. I think they start with the lowest number that makes the cut, and they go up through the chairs and fill the jury that way. They might also do a random draw, but I think they'll do it out of the 50 that are here or so. I guess now we're down to, I think we're down to 48 now. But this is the panel that's been assembled through the multiple days of jury selection throughout this, beginning of this week. The trial begins as soon as they're done with the jury, and that could happen quickly, next hour to 2 hours. The shirt we're talking about here, let me keep the audio on, but I'll show you really quickly. The shirt is this one right here. Inmate seeks attorney. This is her ad that she had in her letter from when she was pro se. She drew that up in pen and asked that the judge publicize it. And so Greeners thought it would be a good idea for me to have a shirt that I could wear or show on the live stream. And shortly after doing that, her attorney said, "Hey, I saw your ad." And so we sort of take credit for the fact that she has an attorney now. I don't know where he saw the ad, but props to Mr. Owens, taking this basically pro bono.
State, do you recognize our panel? Defense, do you recognize our panel?
Yes, Your Honor.
All right, members of the jury, again, if you could please, you can be seated, thank you. If you just raise your paddles to confirm that you complied with the court's instructions during this last break. Record reflect all paddles have been raised. With that, Mr. Henderson, you may proceed, sir.
Yes. May it please the court, counsel. Ladies and gentlemen, good afternoon. That was my first challenge in public speaking. I've been practicing all day that it's good afternoon because we're here in the afternoon. I'm used to saying good morning. So even I have challenges when it comes to public speaking. I want to thank you for being here. Again, my name's Tony Henderson, and it's my pleasure to represent Sarah Boone. And I know the judge has told you, but on behalf of our defense team,
this is still jury
in regards
selection.
to Ms. Boone,
still jury selection.
We would like to thank you. And I'm going to tell you why. America is still great. And the reason that America is great is because of systems like this that we have. And it's our Constitution. Because in this country, our citizens are protected. In this country, we have limited government. In this country, based on our Constitution and the Sixth Amendment right that we have in our Constitution is the right to a jury trial.
Preach, brother, preach.
Folks, in some countries, they don't have that. In some countries, you don't have a jury. In some countries, they have professional jurors. In some countries, only a judge decides. In some places, you have to prove yourself innocent. We don't have to do that here. This is the way I rank these things. And of course, I have my bias as far as what you can do, the service that you can do for your country. I have this ranking. And I have a bias when it comes to this ranking, and I'll tell you about it. But number one, I think, by far, is military service to your country. Number two, I believe, is jury duty. And my bias for the military service is the fact that my dad spent 22 years in the Navy.
I'm going to object. No pending question.
Overruled for now.
Thank you.
Object, no pending
Number
question.
two is jury duty. Quite frankly, it's probably something I'll never be able to do because of the position that I'm in, but I would love to do it. Truly, folks, it's you that make this system work. All right? And number three, I think everybody should vote. Okay? Now, I want to talk to you about the trial process, and this is voir dire. And voir dire means to speak the truth. This is my only opportunity that I will have to talk to you. Okay? Because once these proceedings start, it is against the rules of conduct for us to have any communication with you on either side, being on the state side, being on the defense side. So if you were to run into us or see us somewhere and we don't look at you or we don't acknowledge you, we're not being rude. Okay? We're just following the rule. And it gets ingrained in us because this afternoon, when I came up the elevator, it was a couple of people with jury badges on. I made sure I didn't say anything. Okay? But that's the reason. But for a trial, I break it down to it being 4 fundamental rights. And these 4 fundamental rights apply to everyone. They would apply to me if I was on trial. They would apply to you if you were on trial. They would apply if you had a loved one or a friend on trial. Today and for the rest of this trial, they apply to Miss Sarah Boone. And the first one of these fundamental rights you've already heard about. But sometimes people say things differently. And the first one is the presumption of innocence. We've all heard that term, correct? Raise your paddles if you've heard that term. You probably heard it enough yesterday. But prior to yesterday, I'm sure you've heard that term before. Is that correct? Could you raise your paddles if that's correct? And all of you have said that you can presume Miss Boone to be innocent. Okay? That means at some point in time, and the judge is going to read you an instruction, and I believe the judge already did yesterday, that presumption of innocence means that you believe that she is innocent.
Courtroom audio is, the feed is clicking in and clicking out. Still shows good connection here on our end. Might have Chris change connections. All right. Paddle counter. Raise your paddles high. Here's my paddles. Hang on. We're waiting for to Chris down there check the media panel to see what's happening. He's here. He's here. Okay, can you sit down and talk? Oh, here we go. There we go. Hold
on. Okie doke. I have no idea what's going on with the channel right now? Okay, we had Sarah Boone on for just a second, and then it went away. And so I know that Scott's working on that right now. Scott is on his way back. He's going to be here in just a second. The issue is that we have no we have no heater right now, and one of our kids is sick, and so no heater means it's like in the low 60s and it's just not good for him. So we called somebody to come fix it. And then we looked at our filter and we said, oh my gosh, let's fix that before he shows up. And he just pulled up. And so Scott is downstairs sticking this filter in like it's been there forever. So that's what we're doing. So he's just going to stick it in there, show the guy where the heater is so that he can go down there and make our lives just so much better. I'm so glad you can be patient. Okay. Man, I wish I could tell you what was going on. That was Sarah Boone for 2 seconds. And now we're looking at Top Mark Media again. Interesting. I don't think you can see me, can you?
About the presumption of innocence and how we are, can we all set aside and presume Sarah Boone to be innocent?
Okay, we've got very spotty.
Thank you very much. The second one of these I want to talk about.
I feel bad interrupting him, but then I also feel like he's sort of interrupting me.
Proof, okay? You heard about that yesterday. The judge told you in any criminal case, it's burden of proof. It does not have to prove anything. Okay. Well, jury number 6. Sir, do you know why the state has the burden of proof?
Test time. What would you guys say?
Why should it be? Do you think it should be that way? That the state?
If they're prosecuting her, yeah.
Why?
That's the law.
Okay. Can anyone else give me a different reason by show of paddles that?
There's a quiz, you guys. I don't know if I could pass this quiz. Okay, we're only getting little pieces, but this is pretty standard stuff. Can you be fair and unprejudiced on this? Can you be unbiased? Can you understand that she is innocent until proven guilty? All of this stuff. I don't. He's like testing them. That's the wrong answer. Does anybody else in the audience have the right answer? Chat, what's the right answer? Do you own a suitcase? I have the paddles, but I do not have the know-how of how to get my face on the screen. So I'm holding them up. I'm waving them. The answer is always all of the above. I know A and B, but not C. I don't know. Why? Because it's part of the U.S. Constitution. Sorry. I don't know what they're talking about other than just basic... you have to understand that coming into this, you need to be open-minded and listen to all of the evidence and make your decision based on the evidence, not on stuff that you have heard before or anything like that. Yeah, who's going to volunteer? I would be so embarrassed. Yeah, I would put your chats up on the screen, but there are, I think, 3 or 4 mouses up here. I don't know which one connects to that. Oh, I'm turning all the things on. Do you like to play hide and seek? Why are you asking me? Don't you know the answer already? Can you imagine being in the jury? Wait a second. Don't you know? Okay, I'm out. Scott's coming back.
Has it been like that?
It's, yeah.
Let's see. Let's see if we can fix it here. What did she break while I was gone? She's the best wife ever. I love her. I have no idea what she said. Okay. Okay, it's trying to reset up the feed. I don't know why it's dropping out. They're taking pictures of the media portal. Let's see. Pictures showing up. Oh, here I am. Did she not appear on camera? Did she hide? Tried putting it in rice. Shows we're connecting. Shows we're connected. I've got the guy's voices you're hearing in the background is the guys down in the basement fixing my heater. It reestablished it. Here we go. Need about a 10-second delay.
Element A. As to element B, there was...
It's dropping out again.
But as to element C, you have a reasonable doubt.
Hey, Chris.
Okay, and I used to try to say, Granny, it don't work like that. But that was her fundamental belief. Okay? Is there anybody who feels fundamentally like my grandmother? Anyone? And it's something that I forgot to tell you when I went into this for dying, talking about it's to speak the truth. And why this is so important at this point in time, folks, because guess what? I can't read what's in your mind. Okay? I can't. But more importantly to me, I don't know what's in your heart. I don't. So you have to tell me. And if it's something I say that confuses you or you don't understand, raise that paddle and I'll try to clarify it. Okay? All right. So, do you know what that means? Because the judge is going to give you an instruction about if Ms. Boone elects not to take the stand. And that instruction is going to include that you cannot consider that in any way in your deliberations. Do we understand that?
She has to take the stand.
Okay, great. So guess what, folks? You're back there. And you're talking, and it's close. And someone says, well, we didn't hear from Ms. Boone. Nope. That's wrong. Do you understand? Because you cannot consider it in any way. Do we understand that?
Yes.
Okay. Can we all adhere to that? Okay. Anyone with a problem with that? Okay. Thank you. So none of my grandmothers out there. All right. All right. I'm going to get to some more case-related questions, as I call them. I just want to make sure, is there anyone here who knows someone with the state attorney's office anyway? Is there anyone here who knows someone from the state attorney's office? Anybody who works at the state attorney's office? Show of paddles if you do. No one? All right, good. Thank you. All right, there was a question asked yesterday about interactions with law enforcement or who knew people or related to or had friends with law enforcement. I remembered we took them down. I want a follow-up to that question that I just want to ask you, okay? Is it anyone who has such a close relationship with law enforcement that it would be hard for them if they're on this jury and after they listened to the evidence and said to themselves, the state did not prove this case. And we had to find her not guilty because we followed the law. Is it anyone in a relationship would have a problem telling that person that's what we had to do and that's what we did? Anyone in that type of relationship? Okay. Thank you. Now, in the state of Florida, there are certain things that we have that are known as affirmative defenses. Okay? One of these things that we know as an affirmative defense is the justified use of non-deadly force and also the justified use of deadly force. Okay? AKA, meaning also known as self-defense. All right? I think everyone's nodding now because they recognize that term, self-defense. By the show of panels, how many people recognize the term self-defense? Is it anyone here who disagrees with the principle that a person has the right to defend themselves? Show of panels. Anyone? Okay. Is it anyone who disagrees with the thought that a person has the right to defend others? Anyone fundamentally disagree with that?
Defense of others. How would that apply in this case?
Basically, what I'm asking is anyone who thinks that slap my cheek and let me turn the other one to you so you can slap it? Anyone? Okay. has it been anyone in this panel who's ever been put in a situation where they had to defend themselves? Just show of paddles, please. Yes. 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 Anywhere.
Does that mean fighting?
Those are all good questions.
Does that mean
anywhere
in court?
that you've been in a position, it could have been at school and someone's come up and started picking on you or hitting you or whatever. Do you understand? Okay.
It's just physically defending yourself, though, not, saying you're going to say that.
Yes, we're talking about physically defending yourself. School, middle school, it could have happened. It could have happened when you were in diapers. Okay? Yeah. So, at any time in your life, have you felt, or did you have to defend yourself? Can we show us paddles, please? Okay. Could you hold him up? And we'll start because my arm would get tired. It was getting tired yesterday.
So what if when I was a baby, the doctor spanked my butt when I was born?
This is my left side, so on the right side, correct? Okay. Yes, just on this paddle. And that's paddle number 1, paddle number 2, paddle number 4, paddle number 5, paddle number 6, paddle number 7, paddle number 15, paddle number 17, 18, paddle 32, paddle 41, paddle 43, paddle 44. Then we're going to be in paddle 47. I'm sorry, sir. Were you holding it down low? I just missed you. Yeah. Okay. Thank you. Now, this side. Paddle number 14. Paddle number 24. Paddle number 26, 27. Paddle number 36, 38, 48, 49, 50, 51, 53. Okay. Would you all agree with me that each of those situations would have been different? Anyone who disagrees with that? Okay. So would you agree with me that each of those different situations, if you disagree, just raise your paddle, that each of one of those situations would have to be determined on their own merit and their own facts? Would you agree with that? Okay. Is there anyone who disagrees with this? A person has the right to defend themselves, even if it means using a weapon.
Judge, objection from statement of the law.
Approach.
Objection. They have a right to defend themselves even if using a weapon. In this case, the weapon would be what, a suitcase? Or are they talking about the baseball bat? Because I believe the state has said that they, the part of their story, their scenario, their theory of prosecution is that she used a baseball bat on him, possibly while he was in the suitcase. This is the tail end of jury selection. This is defense. Defense is the last person to go. We've had the judge has his turn. He's dismissed everybody who has for cause reasons that just they're not able to serve. Prosecution's already gone. They've had more people dismissed during that.
The objection is sustained. Mr. Henderson, you may continue.
Sustained. Now defense will be last. Then they'll seat the jury and begin.
All right. As I told you before, there's two types of self-defense. Okay, self-defense with non-deadly force. All right, we're not going to be talking about that in this line of questions. All right, and the line of questions that I'm talking about is that self-defense with what's known as deadly force. Okay, that's basically force that is likely to cause death or great bodily harm. All right, do you understand me there? Okay. In that situation, you have to be in fear of that time, the person has to be in fear of that time that is going to be an action against them or a threat or an imminent threat against them of being harmed with great bodily harm or death, or a forcible felony is being attempted on them. Do we understand that? Examples of forcible felonies are aggravated assault, aggravated battery, felony battery. Some examples. Okay? In that type of situation, is it anyone who believes that a person should not be able to use a weapon in defending themselves? Is it confusing?
Yes.
Depends on the situation.
This attorney, his speaking style is a little confusing.
Paddle number?
Yes, please. I will. Paddle number 24.
It depends on the situation. I mean, they can negotiate and walk away. And if you're against the wall, then you want to can, but always trying to walk away as peacefully as you can.
Okay. Now let me ask you a couple other questions, sir, during number 24. Yes. Thank you. During number 24, when the court reads you the law on justifiable use of deadly force, will you be able to follow that instruction?
Yes.
Okay. Now, would you agree with me that every situation is different?
Yes.
Is that correct? Okay. Let me give you an example. If someone was to put a gun in your face,
right?
Okay, do you think that you have to wait for them to fire it?
No.
Before you fired your gun?
No. Self-defense first.
Is it anyone who thinks that you should have to wait? Anybody? Okay. So in certain situations, based on the facts, are you saying there would be times when you feel it would be appropriate to have to use a weapon? Or I don't want to put words in your mouth. You tell me.
Well, if your life is in danger, you do what you can. It depends on the moment that you're in, but even though you try to look for peaceable solutions, but if your life is if your back is up against a wall, there's a knife at your throat, you do what you can. Not the intent to kill, but to resolve the situation without being killed, if you understand that part, yeah.
Okay. Would you judge it by each situation, sir?
Yes, every situation is different.
Let me ask you this. Would you consider physical ability when it comes to it?
Can be physical, and it can also be negotiating verbally. Sometimes that works. Depends on what the attacker's motive is at that time. So,
Well, let me give you this example, and then you tell me about that. What if it's a male, 6'5", 200 and something pounds, and a female, 5'2", 105?
Objection.
Approach.
If you notice, a couple of comments have been deleted. We ask that there's no all caps in chat. The conversation here, we're all friends. We're all here for the same reason. We love trials. We love the jury system. We love courts in general, and we're intrigued by the case. So please share your opinions respectfully. I ask you not to call names or point at physical appearance is generally off limits. Especially in a way that you wouldn't want somebody to say about your kids, to them. So let's be kind to each other in chat. We're all going to be friends at the end of the day. We don't have to agree, but also no all caps, because that comes across as yelling in chat, and it sort of escalates the conversation. It makes too much work for the mods. So thank you very much for that. They've approached again. Mel says, I have to be nicer than I am to my kids. Dad's in the house. Yep. This community is amazing. It doesn't take long to realize that this place is different than a lot of other places on the internet and even on YouTube. So we just ask that you remember at the end of the day, we might not always agree, but we are still friends at the end of the day. And let's just communicate as if that's the case, because it is. Feel like opening statements tomorrow. Christine, I will tell you the pace that the defense is asking these questions and the difficulty with which he's having them clearly understood. I'm losing hope that we get
Objection is
closing
sustained.
today.
Mr. Henderson, you may continue.
Yes.
Or opening today. Don't want closing either today.
Sir, I need to change that. Male, 6'5", 200 and something pounds. Okay? Female, 5'9", 120 pounds. Okay? Would you consider that when it comes time to how a person would have to defend themselves?
Yes. If it's life and death, it's either their life or your life. So yes, it would be, if that's the last resort and there's no other recourse, I would say yes in that situation, because it's either their life or your life.
Okay. Yeah. All right. Let me ask you this, so, and looking at like when you say it like that, but would you be able to recognize the difference in probably the physical abilities of a man who's 6'5" and 200 and something pounds versus a woman who's 5'9" and 120 pounds?
This juror's like, why are you picking on me?
Well, are you talking about the lady defending herself against the guy that's...
Yes, sir.
Well, in that case, it's survival, you know. I mean, she can either run away or depends on... But, I mean, my point is you try to avoid deadly force if at all necessary. I mean, that's the last resort. But if you can, you don't use it. But if that means your life, then, of course, in that case.
Okay. Thank you, sir.
Yes.
Juror number 5.
Pass the mic down to him.
What's your opinion on that?
As a woman, I would want to defend myself. It doesn't matter how big of a guy. I'm going to try to defend myself until he either hurts me or I take him out and get away.
Okay. Do we have juror number 10 here? No. You got me. I should have had my seat chart. 10. Juror number 17.
If you have a larger, more imposing person, it's a physical altercation with a smaller person. A smaller person is going to have to consider themselves and others.
They're really quiet.
Can we get the mic over there, please?
Yes.
Sir, yes, could you repeat that, please? Juror number 17.
Thank you. Does that work?
Yes.
What I was saying is if there's a larger, more imposing physical presence there that you're fighting against, that could put you in a situation where you have no choice but to use whatever's available to you, because in the example you gave, you're not going to win that fight 99 out of 100 times.
Okay. Thank you, sir. Is there anyone who disagrees with what juror number 17 just said? Hold your panel up if you disagree. Is there anyone here who, are you holding it up that you disagree, sir?
Only slightly. I just only disagree with what he did. I think it's more likely than 99%.
Okay. Thank you.
Statistically, 99 out of 100 is probably not the right
Anyone else who disagrees? All right. How many people show a paddles who agree?
Deborah, thank you so much. Appreciate the support.
To what he said. Who agrees? Okay. Thank you.
George was not the 6'5", 200 pounds attacker in that scenario.
Do you all understand, in the state of Florida, when it comes to defending yourself, either with non-deadly force or deadly force, that you don't have to wait for the commission of the act? Do we understand that? Am I confusing anyone? Okay. Meaning that if someone holds their hand up and fist up and make like they're going to hit you, do you understand that to use non-deadly force in that scenario, you don't have to wait for them to hit you? Do we understand that? Okay. Also, in the use of deadly force, if someone holds up a gun, all right, you don't have to wait for them to fire it.
He said that 3 times.
Do we understand that? Yes. Is there anyone who disagrees with that? Also, in the state of Florida, if it's two people or someone has knowledge of a person or the other person who's exerting force on them, if they have had difficulties or events in the past, that could be considered in their use of either non-deadly force or deadly force. Do we understand that? All right, if you understand that, show of paddles, please.
To get there, you'll need her to testify.
Okay.
She'll have to testify of prior acts.
I don't understand what you said.
All right.
Thank you, juror.
Let me try to give you an example. A and B are school kids, okay? They go to school every day. Let's say they're in middle school, all right? And for the past couple weeks, you know, A has been beating on B, okay? So.
Is B for Boone?
A and B go to school again one day. Next thing you know, A comes up to B. And B just automatically hits A.
Approach.
Objection. The judge is like, let's hear this. He's trying to paint a scenario, what the lawyer's trying to get to, and he's struggling to do this in front of the jury. He's trying to say, can you imagine being in the spot where you have been the victim, you've been the victim, and then you come back together and you're not being victimized in the moment, but you use that moment to defend yourself. And that's basically the story we're going to hear them tell through defense.
Mr. Henderson, you may proceed.
Let me try to explain it to you like this, ma'am. If you hear an instruction that you can consider past difficulties between the parties if in determining if someone was justified in using non-deadly force and deadly force or deadly force, could you follow that instruction? Yes. Okay. Is there anyone here who could not follow that instruction?
Another objection.
Yes, ma'am.
I need a microphone.
Oh, okay.
We get juror number 13. a mic.
I'm not doing a good job with the mic. I'm sorry.
The juror's like, give me the
So
mic.
like in your
I wanna
example, if I'm allowed to use the example that you were just using on A&B, no.
Not the example that I used before. Okay. That was found to be wrong.
Okay. So I guess my question is, even though there's been past events that have happened and they could weigh in with that, something still has to be happening in that moment for them to defend themselves in that way, right? It's not like somebody walks up to you and you can just defend yourself.
You're absolutely correct, man. Because what the statute is going to say and what the instruction is going to say, that has to be an imminent threat, okay? An imminent doesn't mean that you have to wait for it to happen, but you have to have reasons to believe that it's going to happen, okay? But the instruction that I'm talking about, do you understand that past difficulties can be considered? Because that's what the jury instruction says. Can we follow that instruction? Yes. Is that correct? Can you follow that instruction, ma'am?
Yes, sir.
Okay, thank you very much.
The juror asked for the mic. That's funny.
How many people here own guns? Or at least one gun? Okay. Let's start on this side over here. Juror number 4. I'm not going to ask you how many you own. That's your constitutional right. I'm not going to. I asked that one time. Somebody said, "I'm not telling you how many I own." So I learned from that. What's the purpose of your gun?
My American right.
Yes.
Self-defense, and then they're just fun to shoot.
Okay. All right. Thank you. Juror number 5.
So they're actually my husband's, and he had purchased one for me for that reason. If he was home or not home and I was by myself with my child, someone were to break in, we would have us self-defense.
Okay. Thank you. Who else on the first row on this side owns a gun? Anybody else? Second row? Yes, sir. Juror number 15. Excuse me? You have to speak up, juror number 15. Oh, there we go.
It's basically for home defense. That's all.
Home defense? Okay, thank you. Anyone else on the second row on this side? Juror number 17.
Exactly what she said. Exercising my right, self-defense, and I like to target shoot.
Okay, thank you. Anyone else on this row? Yes, sir. Juror number 19.
Self-defense.
Self-defense.
I don't really shoot, but I have it in case I need it.
Okay. Thank you. Anyone else on this row? Third row on this side. Anyone owns a gun? Okay. Last row on this side. Anyone? Let's start with juror number 44 because she has the mic, I believe.
Same reason as the lady up front.
Okay. Thank you. Juror number, what's your panel number, ma'am? 43. Thank you.
For self-protection, I live alone, and also in my job I have drugs, and so I'm a veterinarian, so if anyone knew that and people are crazy, then they might want to break into my house and try to or into my truck.
From her voice, I thought she worked in the office.
Well, in other words, if anyone gets froggy.
I'm sorry?
I said froggy. It's a slang term. I'm sorry.
Yeah, so just, it makes me feel safe.
Okay, thank you. And sir?
Yeah, just old hunting shotguns.
Okay.
Hunting rifle from my father and grandfather.
All right, thank you. Anyone else on this side own a gun? This side, if we can have the mic come this way, would be great. Oh, they have a mic on this side too? That's great. It's like a relay team. All right. Juror number 23.
For self-defense.
Self-defense. I like your juror number, sir. That was my football number.
Home defense, and recreation.
And recreation. Thank you, sir. That was juror number 24. This is juror number 26.
Home and self-defense and shooting practice.
Okay, thank you. Anyone else? Oh, did I get the first row here? I didn't get it first. Yeah, juror number 8.
Sport and recreation.
Sport and recreation. Okay. Were you able to hear that? Okay. All right. Now, I'm on the third. Anyone else on the second row on this side? On the third row on this side, anyone gun owner? Juror number 37.
Just for recreation and home defense.
Okay. Anyone else on this side? On this row, I'm sorry. Back to juror number 51. Thank you, ma'am.
I don't own a gun, but my husband bought one for target shooting. I don't even know where it is, so he's got it locked up somewhere.
Okay.
But it's not for home defense, though.
Okay. Well, thank you, ma'am.
Is that it?
Recreation, home defense, and our rights.
Your number, please, your panel number. 49. Okay. Thank you, sir. Anybody else? Anyone I miss as to gun ownership? All right. Thank you.
Nobody uses one for income generating
Folks,
purposes?
If you disagree with this, raise your panel for me. Yeah, I'm sorry. I'm about to say it. If you disagree with this, raise your panel, okay? Your home is a sacred place.
If you disagree, sorry. I wasn't paying attention. Ask
Yes,
the question.
anyone disagree with it? Your sacred place. Your home is a sacred place, okay? All right, let's do it this way. I'm sorry, yeah. I did it the wrong way. Let's do it this way. If you agree with this statement, raise your panel, please. Your home is a sacred place. Okay. Is there anyone here who believes that you can't defend yourself in your home? Okay. If you do, raise your panel. All right. Thank you.
They need yes, no paddles.
All right. It's going to be one other thing that I'm going to talk about with this justifiable use of non-deadly force or justifiable use of deadly force. Okay? And it ties in with the burden of proof because remember, it's the state, the government, who has the burden of proof. All right? However, folks, once the judge reads you an instruction saying that it's an affirmative defense of justifiable use of deadly force or justifiable use of non-deadly force, do you understand that Miss Boone does not have to prove to you that she was acting in justifiable use of non-deadly force or justifiable use of deadly force? Do you understand that?
It's a poorly worded question.
Guess what has to happen?
The state has to prove it.
Juror number 3. I hadn't picked on you. What has to happen, sir? Do you know what has to happen? What do they have to prove? Yeah, you're really close, but this one's tricky. You're really close. You're almost at that. But you know what? The state has to prove to you that she was not acting in self-defense.
Once she raises self-defense.
Deadly force or non-deadly force. Do we understand that? Okay, because it gets a little tricky when you think about it. So she doesn't have to prove that she was. Once the instruction is given, she doesn't have to prove that she was. They have to prove that she wasn't.
The burden
shifts
to the
understand
state once
Can we
she's
all
properly
follow
raised
that?
self-defense.
Is there anyone who thinks it should be a different way? Okay.
This is not Owens. This is his assistant, his second chair.
Is it anyone here, and I think a little bit of this man came up yesterday, that has ever been in a situation that either they were abused or part of an abusive relationship, or they know someone who was abused and part of an abusive relationship? Show of panels, please.
This is going to be a tough one. These are the questions that the jury is hesitant to answer.
And if I remember correctly, didn't we cover this yesterday and these things? All right. So I just have a couple additional things that I want to talk about when it comes to this. Folks, is there anyone who disagrees with this? That sometimes people are just embarrassed and don't want to talk about those situations. If you disagree with that, raise your panel, please. Do we understand that? Okay.
The reason he's saying if you disagree, raise your panel.
Would you agree with this, that sometimes the person being abused tries to minimize the situation? Is there anyone who disagrees with that?
No, he says both ways. Disagree is easier to see if somebody raises a paddle than everyone raising their paddle saying, I agree, and you're looking for the one who isn't. So he's asking the questions, hoping that it'll be easy to see. But his wording is terrible.
Is there anyone here who either themselves, yourself, or knows someone who has stayed in an abusive relationship over an amount of time? Raise your panel.
An amount of time.
Okay.
Thank you, Samantha. I'll pin this one.
Is it anyone here who has ever tried to talk someone into leaving an abusive relationship? Raise your panel. Okay. Thank you. All right, we're going to start over here. Juror number 2. Without telling me who it was or what the situation was, did they follow your advice?
Yes, in the end.
In the end? Did it take a while?
Yes.
About how long did it take?
There were a couple of different instances. So one of them took about a year, and then another learned about it as they were getting out of it, but they had been in the relationship for a number of years before I even met them. But they ended up leaving after about a year and a half to 2 years. I don't remember.
Okay. Anyone else on this front row who had to paddle up? All right. Second row on this side. Anyone? Yes, ma'am. Did the person listen to you? The microphone's right behind you, too. I'm sorry.
No, they did not.
How long did you try?
Well, over a year.
Okay. Thank you, ma'am. Anyone else on this row? This second row? On this side? Ma'am? 21, can we pass the mic down, please?
I, too, found out late in the game, but when I did, it did take a little while, a couple months.
Okay. Thank you. All right. Anyone on the third row? All right. Thank you.
He's got to ask the hide and seek question.
She left the person after about 10 or 11 years, but it was not because of anything I said. And I did talk with her the entire relationship.
Okay. Thank you. Anyone else on this third row? Fourth row? Yes, ma'am. Juror number 43.
One girl, I tried to help her, so I let her stay with me, and I brought her here to do a restraining order, but then it all fell apart. And then she was a mess, so I got her out of my life, but I don't think that it would have made any difference. Okay. And then I also know quite a few clients, not very well, but you see it happen over and over, and people usually don't leave.
Thank you, ma'am.
Does she work in this field?
Is it anyone else on this row? Okay, let's go to this side. Anyone on this side? Juror number 8. Where's our mic here? Here it comes. Yes, sir.
No, they did not leave the relationship.
Okay. How long did you try? to talk to him?
Years.
Okay. Thank you. Anyone else on this row?
This is a good line
Yes,
of
ma'am.
questioning for the defense.
Juror number, please. 13. Got it.
Same years, and I think in most cases that I've seen, like it just has to be them that finally makes the decision. It doesn't really matter what you say.
Okay. Anyone else on this front row? All right, second row. Anybody? Juror number 28.
It was about 2 years. They eventually left on their own accord, but I was there and the support offered a safe place and they would go back and forth. It has to be their decision.
Ma'am, thank you very much. Did y'all hear that? When they said it has to be their decision. Is there anyone who disagrees with that? Basically, it has to get to the point when they say they're done. Is there anyone who disagrees with that? Okay. Thank you, ma'am. Anyone on the third row? Anyone on the last row? Yes, ma'am. Yes, sir. Where's our mic?
Thank you, Ella. Congratulations.
3 years, they didn't listen. The guy ended up leaving her. She would gladly go back to him probably today.
Okay.
That type of person.
Okay. And that was hard for you to understand, wasn't it?
No.
No?
As I grew older.
Okay. That's fair.
It was a much simpler place.
That's correct. Well, simpler in some ways, harder than others. Anyone else on this row? Yes. Juror 50.
My cousin is off and on in the relationship. The family knows. We've tried to talk to him. It's ongoing.
Okay. Anyone else? Yes, ma'am.
A colleague, and I talked to him for maybe a month, but they did it on their own years later.
Years later? Thank you. Is there anyone here in the panel who's ever had an injunction filed against them for no contact, that you couldn't have contact with a person?
A restraining
Anyone
order.
here? Okay. Excuse me? Somebody else, but not.
Filed one.
It wasn't against you. Is that right, ma'am? Okay. Thank you very much. Yes, sir.
Didn't really have filed against her or anything, but her and the neighbor got into it.
Okay. All right. And that was your wife, correct? Not yourself. Okay. Thank you, sir. Thank you for your candor. All right. Anyone else? Thank you. And that was jury number. What's your panel number, sir? 15 and ma'am, 13. I got it. This term came up yesterday, battered spouse syndrome. There were some people who said that they were familiar with the terminology, okay? So I know that, and we have that information, okay? But this is something that I want to talk about. Is there anyone here who knows someone, friend, relative, who just knows everything about anything, if that makes sense? Anybody show a panel? Do you know someone like that? Okay. All right, so there's very few people who know someone like that. Well, we all agree that there are just things in life that we don't know about. Right? Anyone disagrees with that panel? Okay? Guess what? When my car breaks down, I'm going to the mechanic because I don't know a thing about a car. Okay? Now, when my AC or air conditioner goes out in the summer, I'm calling the guy as quick as I can because I know nothing about the AC. Do you understand that? Okay. So, when the car guy says, oh, Mr. Henderson, this is going to cost you about $2,000. You know, what do I want to do? Or what does a reasonable person? Well, what's wrong with it? Okay? But guess what? It gets to a point I have to rely on the car guy because I don't know about it. Do you follow me there? If I get sick or if anyone gets sick, where do you go? Do we have any doctors out here? Okay. Thank you, ma'am. And did you say that's the vet clinic? Do you?
Yeah, I'm a veterinarian.
You're a veterinarian? Yeah, I have a German Shepherd.
Except the patients don't talk to you, so.
Yeah. Yeah, I let him stay with some people who had dogs, and he don't even miss me. I've been here in Orlando all this time. But, so, what do you go to the doctor for? Yeah. Aren't you trying to find out what's wrong? Okay. Folks, there are some people under the law who become expert or known as expert witnesses. Guess what? Because they know about a topic more than we know about a topic. Do you agree with me there? Is there anyone who disagrees with me on that? Raise your paddle if you disagree.
There's a canine.
Had to play that sound.
Can you all, by show of paddles, listen to an expert testimony and weigh it accordingly? Can you do that by show of paddles? Everybody can do that. Is that right? And guess what? You're not going to hear me say anything else about an expert because I really don't know about the expertise. That's why we have the expert. The expert can talk about it. Okay? We agree with that? Everyone agree? Okay, thank you.
We're just finishing up jury selection.
Right.
This is the defense asking questions of the
There's
panel.
been talk about fear and fears and what kind of fears people can have. Okay? If you disagree with this, just raise your paddle. Oh, no, let's do this. If you agree with this, raise your paddle. Okay? That some people can have the fear of not being wanted. Do you agree with that? Okay. Thank you. Anyone disagree with that? Okay. Some people can have the fear. Oops, excuse me. Yes. Thank you. Number 6. I'm not even going to ask you to explain it because I understand some things we just don't agree with.
Like wanted by the police,
All right.
I think
Thank
he was
you,
talking
sir.
about.
All right. Some people can have the fear of not being good enough. Would you agree with that? Okay. Is there anyone who disagrees with that? Number 6. Okay. Thank you.
Number 6, please.
Paddle number 6. Thank you. All right. Some people can have the fear of being hurt emotionally or physically or both. I said that all backwards, though, but you know what I mean? I should have said emotionally, physically, or both.
You also didn't say whether you agree or disagree.
Anyone disagree with that?
Okay. It's the negatives are killing
Number
people.
Number 6. Good. Okay. Is there anyone in the panel by show of your paddles that's claustrophobic? Okay. Can we keep that up? We'll start on this side first. Juror number 3. Thank you. Juror number 34. Thank you. Juror number 44. Thank you. 44. Did you get it, Miss Andrews? Okay. Yep, you can put your paddle down there. Juror number, this side, paddles up, please. Juror number 9. All right. Juror number 40, juror number 51, juror number 53.
There goes the whole jury.
All right,
Everyone's
thank
claustrophobic.
you. Is it anyone here, maybe I asked this another thing, but let me make sure, who has a medical background? I don't mean a doctor, but just has a medical background. Okay, let's do this. Could you hold we're going to start on this side over here. Could you hold your paddles up high, please? All right, so we're going to go juror number 5, juror number 16, juror number 18, juror number 21, juror number 31, juror number 43. Thank you. Anyone else on this side? All right, on the right side, juror number 51. Anyone else on this side? Thank you very much.
This is a normal process. The questions are unique to this trial.
All right. I have to talk about another topic here. Alcohol. It was brought up yesterday. Okay? So this is what I need to ask you. If anyone disagrees with this, just raise your paddle if you disagree. That alcohol affects people differently. Anyone who disagrees with that? Well, let's do it with agree. It makes it easier. I'm sorry, I get confused. I'm confusing people. Let's do it with agree. Anyone agree? Who agrees with this statement that alcohol affects people differently? Do you agree? All right. Anyone who disagrees with that statement? Okay. Now, would you agree with this? Who agrees with this? That sometimes people or certain people drink alcohol and they get happy and giddy. If you agree with that, raise your paddle. Okay.
Happy drunk, angry drunk.
Sometimes
drunk.
people drink alcohol and just get downright mean. Do you agree with that? Raise your paddle. Okay. Anyone who disagrees with that? All right. Folks, sometimes there's people who don't drink a lick of alcohol and are just happy and giddy. Would you agree with that? Okay. Anyone who disagrees with that? Folks, sometimes there are people who don't have a drop of alcohol and they're just downright mean. Do you agree with that? All right. Thank you. Now, I think yesterday it was juror number 4. Juror number 4, correct? You drank, is that correct? And we talked about drinking yesterday, is that correct? Okay, let me ask you a couple questions about drinking. Have you ever drank and did something that you would not normally do when you're not drinking?
Like film something
Okay.
you regretted?
All right. Have you ever drank and said something that you didn't mean or regretted the next day that you said it? You agree? Has that happened? If you even remember saying it. Correct? Has it ever been a time where someone had to remind you the next day or a couple of days later, you said something rude to me when you were drinking? Has that ever happened? Said things that you wouldn't normally say? Yes. Okay. They could be nice things. Yeah. Right. All right. So.
I regret saying nice things when I'm drunk. Is that what he's saying?
Is there anyone who disagrees with those things? Do we all agree? Here's the thing. Do we all agree that people can do things after they've been drinking that they wouldn't normally do if they were sober. Does everyone agree?
Good approach.
Has anyone, when they're drunk, gotten a suitcase while playing hide and seek? No one? How about we do this? If you disagree, a good place to hide is a suitcase when you're playing hide and seek. So if you disagree with my statement, raise your paddle. This guy is all over the place. It's wild. Tricia Fishburne says, is this the typical process when picking at the jury? Specifically, the defense detailed questions. Yes. Now, the defense is not supposed to use questions that are like literally ripped from the case itself. They can do like vague scenarios that resemble somewhat, but they're not supposed to, put the evidence out there to the juries in this way. But yes, this is normal, and they do try to ask questions to try to figure out, get in the juror's mind a little bit. Like they're gonna find out facts that have to do with this. They're gonna find out that Sarah did some things when she was drunk that she didn't remember, and she said some things she didn't remember, and she filmed some things that she didn't remember apparently. They're going to find that out, and they want to know where the jury stands on what they think about that occurring. Obviously, the prosecution wants to strike anybody that is like, yep, anytime I'm drunk, if I do something, it just doesn't matter. You can't hold that against me. If I do something when I'm drunk. The prosecution would be, well, we probably don't want that person on the panel. Defense would be like, yes.
You may continue, sir.
Foreman, please.
Is there anyone who disagrees that people act differently when they drink? Okay. Now,
that one is overruled. It's the first one he's had that's overruled as far as objections from the state on his examination.
Juror number 26. Yes, sir. Do you drink? Okay. Do you drink at home? Do you drink out socially? Okay. Are your drinking habits any different at home than they are out socially?
Probably a little bit more socially.
Okay. You probably drink more socially? Meaning more occasions or what?
Quantity.
Quantity? Okay. Good. Is there anyone here who drinks more at home than they do out socially? Okay. Thank you. Juror number 38. You drink more at home than you do out socially? Why?
Because I can stumble to my bedroom more than I can stumble to the car.
Hey, man, that's A+. That's exactly it. That's exactly it. Is there anyone here who disagrees with that? Okay.
Oh, my goodness.
Juror number 49. Sir, first of all, I'd like to say congratulations to you, okay, and continued success, all right?
Awesome.
And I actually appreciated the story that you shared with us. I have a couple questions, though, okay? How long have you been a non-drinker?
Well, since 1987.
Since 1987? Okay.
That's awesome.
And prior to being a non-drinker,
35 years of sobriety.
how long did you drink? How many years did you drink?
Probably 15, 18 years.
15, 18 years? If you don't mind this sharing this with you, when did it come to you that you thought or recognized that you had a problem with drinking?
Well, I was going through some difficulties with a wife that I had at that time. I was overseas. The last thing I remember doing was drinking 2 beers, and I evidently blacked out, and I embarrassed myself in the Air Force.
Okay.
It's always 2 beers.
Sir, was there ever a time in your life that someone confronted you about drinking and you denied that you had a problem?
Actually, multiple ways, multiple directions. I had people telling me that I didn't have a problem, and I had people telling me that I had a problem.
Okay. Was it your drinking buddies who were telling you that you didn't have a problem?
Not only my drinking buddies. I had commanders telling me that I didn't have a problem.
Okay. Were there loved ones telling you that you did have a problem?
No, actually, when I confronted them, telling them they had to stop doing that, they actually got a little upset.
Okay. Who was it who was telling you that you had a problem?
Medical personnel.
Okay. Did you listen to them?
Initially, no.
Okay. Sir, can you tell us what changed your mind or your attitude?
To be honest, after numerous incidents, I know my family history. I felt it either I needed to stop drinking or just take myself out into a field and eliminate the problem before I actually hurt somebody else.
Whoa.
Okay.
Whoa.
So you looked in the mirror?
Absolutely.
Is it anyone here who disagrees with the fact that there are people who are in denial about a drinking problem?
People are in denial about a drinking
Anyone
problem?
who disagrees with that? All right, let me ask it in it this way. Would you all agree that some people are in denial that they have a drinking problem?
Yes, I
Thank you.
admit
All
I
right.
have a thinking problem.
This is what I need to ask you now as the panel, and I want you to understand. Because we've talked about how people act differently when they drink, or they'll say things differently, or they'll do things differently when they drink. Do we all understand that being drunk is not an excuse for your actions?
Florida law.
Do we all understand that?
Yes.
Okay. Raise your paddle if you agree with that. That being drunk is not an excuse for your actions. Do we understand that? Okay. Do we understand that in the state of Florida, there is no defense for voluntary intoxication? Do we understand that? So you can't come in the state of Florida and say, well, I did it because I was drunk. Do we understand that? Okay. Is it anyone here that would not hold someone accountable for their actions merely because they were intoxicated or drunk? Anyone here? Anybody going to do that? Okay. All right. Thank you. You ever heard, has everyone here heard the term, by show of paddles, rush to judgment? A rush to judgment. Okay? Is there anyone here who has a story that they can share about them rushing to a judgment and it turned out that they were wrong? Anybody? All right, I have one. Tell me if you can agree with this. In a building one day, come out from the building, I'd done my shopping and stuff. I go out to the parking lot and I'm walking up to my car. And as I get closer to the car, I see that there is a dent, a big dent, in the back driver's side of my car on the bumper. So guess what? I'm mad now because it wasn't there when I left. So I'm going up to it, and I see, man, it's only in my car. So I'm looking for a note, and I don't see a note to see if the person left a note or information. So then I get to the point where now, let me put this in here. Let me go and see if they have any video footage inside so I can see who hit my car. Okay? So on the thing of putting it in there, I clicked my key fob and the door wouldn't unlock. Now I'm really mad because they done damaged everything. Can't even get in my car. I go to the handle and I push with my thumb the button to get in, and I can't get in. I said, oh man, this is just bad. So I walk back to the back of the car and I happen to look, and I said, that's not my Florida State University license plate. Matter of fact, that's not my car. At the time, I was driving a black Nissan Maxima. At this time, this car was a black Nissan Altima without a Florida State license plate. Would you agree with me, folks, that sometimes everything that needs to be investigated? Is there anyone who disagrees with that?
The story was better than the question.
Would you all agree that there should be a full investigation before a decision is made? Would you all agree with that? Anybody, by show of paddles, who would disagree with that? By show of paddles, who agrees with that? Okay.
He just wants you to raise your paddle. That's it. Just raise your paddle. So, Malicious OG, welcome to the gallery. So, George,
when I found my car too, which was behind me over there, I was relieved. But then, I thought.
But you went around the back and checked for
maybe that car was like that beforehand. All right. Now I have to talk about it's one other thing I have to talk about. Remember yesterday there was conversations about you being as the jury, you sit in the position of determining what the actual facts of the case are. Okay, what the actual evidence of the case are, and you have the great power of giving evidence its weight. Some you can consider greatly, some you could give less weight to, or some you have the power just to ignore it all, and you don't even think it's important. Do we understand that? That's your power as jurors. So it's talking about, one of the things we're talking about, one of the things too, you're going to have to determine credibility of witnesses. Okay? Credibility of witnesses. And they talked about some things, and the state talked about some things. Would you like to look at them? Would you just be able to hear them? Or could you be comfortable with that? All right? The judge will read an instruction when it comes time, and I want to know if everybody can follow this instruction. It's going to be weighing the evidence. And the judge is going to give you a series of things that you can use in determining which evidence is the best evidence, which evidence isn't so good, or which evidence you don't find credible at all. Do we understand that? Okay? But I want to focus on one of those. I'm telling you it's more, but this is the one I'm focusing on. Weighing the evidence. Does the witness testimony agree with the other testimony and the other evidence in the case? Do we understand that?
Does the witness testimony agree with the other evidence in the case?
Does the witness testimony agree with the other evidence, the other testimony, or other evidence in the case? Can we do that?
I haven't heard it yet.
Is it anyone who feels that they're not capable of doing that? All right? Now, when we say other evidence, we're just not talking about other testimonial evidence, because evidence comes in different forms. Okay? There could be physical evidence. Do we understand that? There could be scientific evidence. Do we understand that? Or there could be expert opinion. Do we understand that? Can you weigh all those things, follow the law, and make a fair and impartial decision based on the law?
Georgia Culture, congratulations on 21 months.
And based on what else? That high standard of proof, the highest that we have in our country, beyond and to the exclusion of a reasonable doubt as to each and every element. Can you do that?
Is that the big finish?
Guess what? Two more things, I think. I'm going to check with co-counsel too. But two more things, basically. One is this. I'm going to date myself here. Or I'll just go ahead and tell you, I'm 63 years old. Okay? So, and in fact, when y'all had the opportunity to meet Lauren Henderson, okay? She's not my wife. She's my youngest daughter. We are related. Okay? So, and actually, she's an attorney now. She just finished law school and passed the bar. So that's why she's assisting in this case today. Okay? So that's the relationship.
Bring your child to work.
But when it comes to weighing the evidence, this is... No, I'm sorry. I'm past weighing the evidence. I was getting emotional. Anyway, this is one of the things, and she has to help me with it. That's where the age difference comes in. It's called social media. Okay? Guess what, folks?
You can't do it.
I do not have a Facebook page. Quite frankly, until it started becoming prevalent and people looking at them and stuff, I added it onto my board hour thing because they had to tell me, my staff had to tell me what the forms of social media are because I don't know them. Facebook, Instagram. I guess YouTube's one too. I thought that was TV. But Twitter, Snapchat, TikTok, Instagram. Okay?
Say MySpace.
So I become familiar with these things, but I'm looking for something. I'm looking for someone who lives their life on any type of social media. All right? And this is what I'm talking about. So if you're this kind of person, I want you to raise your paddle.
Did you say who lives your life not on social media?
No, who lives your life on social media. Okay? Who lives your life on social media. Well, you'll see with this example. Okay? That's it. Some of y'all are getting nervous, I can tell. You're getting nervous, but here we go. 6 a.m., just woke up. 6:10, headed to the bathroom. 6:20, man, I really don't want to go to work today. 6:35, darn it, let me go in here and see what I can have for breakfast. 6:45, darn it, looks like either Fruit Loops or eggs. 7:05, darn it, I still don't want to go to work, but those eggs I had were really good.
I don't start till 9, so this is not me.
7:30, I better head to work so I don't get caught in this traffic. All right. Anyone who leads their life on any form of social media or texts anyone to that extent, would you please raise your paddle?
No one's going to do it.
Okay. Remember that word, Vordier? To speak the truth.
He doesn't believe him.
Now watch this. Is there anyone who knows someone that does that? I always get a yes to that part. I always get a yes to that part. So no one who knows that way. Is that correct? No one who does it. Okay. Judge, may I approach a minute, please? May we approach a minute?
Yes.
All right. So he's going to consult with his counsel, I believe. The problem with that example, what he just did, was he set the stage, he made it a joke, He used an extreme example of somebody who used way too much social media, and then said, this is a bad thing, basically, by making it a joke, and everyone laughed, and then said, now who here does that? And nobody's going to be like, oh, Judge, sir, it was me. I do that. I'm posting right now. Jury questions taking forever. This guy never shuts up. No one's going to do that. Instead, what he should have done is, how many of you guys use social media? Boom. How many of you post once a day? Boom. How many of you post more than once a day? That opens the door, and then you're like, all right, now we know who is using this. Instead, he doesn't even understand social media, so he used an outlandish example, and he got zero mileage out of it. We just wasted time. Mrs. R.A., hello, my wife. How are you doing? Says, what's social media? Don't know. I'm not into it myself. I think it's a fad. It'll pass.
You may continue, sir.
Thank you, Your Honor. All right, the procedure. When you get here, if you're on a jury, when you get here, you're going to have to turn your phone off. And you're going to have to leave your phone off. Okay? I think they've been having y'all do that now. Is that correct? All right. During deliberations, you got to check the phone at the door. Okay? You're not going to have it. Everyone understand that? Yes. Who's going to go through withdrawals? I need to know. Who is going to go through withdrawals?
Everyone who laughed.
That means you're not going to be able to text someone. You're not going to be able to get on the phone and see who's trying to call you. You know what? You're not going to be able to put that last post on there. Do we understand that? Back in the day, guess what? We used to have to ask this question about cigarette smoking. Okay? I think they allow breaks for cigarettes. I don't think they allow phone breaks. Okay? So is there anyone who is that tied to their phone that they're going to be worried about that phone and not worrying about the evidence and the case and the testimony and everything else? Yes, sir.
Will there be a method for emergency?
I'll defer to the judge.
I can answer that question. So if you are selected to serve as a member of our jury, an emergency phone number will be provided that you can provide to any loved ones or friends or family. And in the event there is an emergency situation, they can call that number and we will get in touch with you.
This is the greatest game.
Thank you.
Judge is such a good speaker. Love him. It's so refreshing.
All right. Judge, can I confer with counsel?
Yes, sir.
Real quick.
Here we go. See if he has any more questions. He may be done.
I'm about.
Let's see if they have anything else they want to bring up, or any jurors they specifically want to tailor a question for, because they can do that. By now, after we've done this, let's see, it's Thursday, so we've had multiple days. Most of this week we've been sending.
You are now, counselor.
I'm back on? Okay, I'm back on. There we go.
I think they know who they want.
In our little courthouse in Santa Rosa County, you don't have to wear a mic. You just, everybody's saying, we got a new courthouse, but it's nothing like this.
Bless you.
Okay. Bless you, sir. All right. Great escape clause. I don't really think anyone has said today that they couldn't be fair or it's anything, but I know you've been responding to questions. This is what I want you to do. I want you to think about it. And if for some reason, it could be anything, okay, that you don't feel comfortable about sitting on this case, if you'd raise your paddle and let me know. But let me give you some examples, because I don't really, before you do that, it could be the fact that you don't like the fact that I move around. You don't like the fact that I look. You don't like the fact of how I sound. Okay? You don't like the fact of, darn, Mr. Henderson, what were you thinking about when you got in the mirror this morning? Okay? That don't match. It could be that. Folks, it could be as simple as this, that you think my hair is way too long. Okay? But now, or it could be something that you don't like about Mr. Owens, that you don't like about Miss Boone, that you don't like about Mrs. Henderson. and that you don't like about Mr. Beck. Miss Andrews is a little sensitive, so I won't say it, but you can consider that too. Okay? So at this time, if you feel uncomfortable, would you please raise your paddle at this time? Okay. Number 40. All right. Thank you, ma'am.
40's like...
Anybody else?
I hate you.
All right.
Oh, my goodness.
Folks, I want to thank you. I want to thank you on Miss Boone's behalf. I want to thank you on our team's behalf. People here have made us very comfortable. Sometimes it's hard going to a different place, but everybody's been very friendly. Y'all have been very attentive to me, and I really appreciate it. And I want to thank you on behalf of me, our team, and especially Sarah Boone. Thank you. Judge, that's all the inquiry I have.
Judge Mouse, thank you as well. All right, the party's going to approach. I think at this point they have their final strikes. And then what's going to happen is the seating chart, generally, because the jurors are randomly selected and placed in order and assigned in order randomly, most courts use that process to say, we're going to start with juror number 1. And prosecution, defense, do you have any objections? No? Okay, they're on the jury. 2, prosecution objects? Okay, 3. And they go through and they'll work through the process. And each side has a limited number of strikes. I don't know how many they have, but generally, if everyone used all their strikes, you would have leftover jurors still by the end of the jury pool. And we started with 50. I think we lost 2 today. We probably have maybe 1 or 2 more for cause. So we're down to about 54. We only need 14 jurors, which is 6 seated jurors and 8 alternates. I think they have 10 strikes each. Okay, so 14 plus 10 plus 10, that's 34. So we have way too many jurors. We're going to have a jury out of this group for sure. Thank you, Justin, for the 10 each information. That's a lot. 10 strikes. We're probably not going to get to 40. 8 regular strikes and 2 for the alts. The Petty Paralegal says, thank you for this and all of your great coverage. Petty Paralegal, thank you very much. Appreciate it. Love that we have people here in chat who are professionals in this realm and can set us straight and teach us on some of the things as we are learning about court in all these different parts of the country. We like Florida. We've been here a lot.
Members of our jury, thank you so much again for your time, your sacrifice, your attention, most importantly, your honesty in answering the court's questions, the state's questions, and the defense questions over the last couple of days. We're going to excuse you for a few moments while we decide who may be able to serve as members of our jury in this case. Please do not leave this floor. There may be some of you that we need to speak to on an individual basis. And again, I'm going to give you a similar instruction that I've given you as well over the last couple of days. Please don't conduct any independent investigation or research regarding the charge, persons, places, or things that are involved. Do not have any communications with anyone else or amongst yourselves about any of those things. One last thing. You may see the state or attorneys for the state and the attorney for defense outside, maybe in the same elevator as you over the next couple of weeks. They're not allowed to talk to you, and they may look away from you. They're not allowed to communicate or have any interaction with you whatsoever. If you make eye contact, they may shy away and look away from you. I promise you, they're not doing it to be rude or insensitive. They're just trying to avoid the sense of any impropriety while we conduct this trial. With that, I thank you again for your time and your sacrifice, and we'll bring you back in as promptly as possible. Thank you.
While they're doing that, I just want to show you on the replay, and I'll do this really fast without audio. Sarah Boone, this is on replay, and it's going to be faster, so it's going to jump. Look at how active she is in this process. So she's very attentively listening. She's watching. She's writing, constantly taking notes, listening, talking. She's been an active participant throughout this process. Yeah, anyway, now we're back to live. So, and we got an earshot. We're within earshot of somebody. I don't know who it is, but they're like, "Hi, how are you?" There's Mr. Henderson. There's Sarah Boone's team.
All right, y'all can be seated. Thank you.
Mrs.
We'll be off the
Henderson
record
is
for a
Mr.
few
Henderson's.
moments for y'all to review your notes, use the facilities, take 15-minute recess. It is 3:30. We'll see you all at 3:45, and we can address any individual voir dire or charging conference at that time. Court's going to be in recess. Thank you.
All right, we'll see if we keep a feed here. Oh, Jules is calling in. She's our court watcher. Just 1 second.
Call from Jules.
Hey, Jules, this is Scott. We just barely heard the judge dismiss everybody for a few minutes.
Well, yeah, the jurors, got to make sure I'm nowhere around them. Put them out in the hall. They're going to announce which ones are taken.
Yeah. They might do a little more voir dire. If I'm thinking juror 40 might get pulled in and say, what's your problem with the defense? Why did you raise your paddle saying I just don't like you? It'd be interesting.
That was number 40.
Yeah. Jules, we've got a really bad connection. We're cutting out a lot.
Oh, hold on a second. Yeah, wait. I'm going to go back in the courtroom. I don't want to stay.
I think we lost her.
No.
Now you're back, but it's really bad.
Okay. So that was juror number 40. She's a young. I want to say she's probably in her 20s.
What's the makeup overall for this panel? We've got roughly 50 people, a few under 50.
We're down to 47 now.
Okay.
Yeah, they started off with 100, and so 47 is what's left. So what do you call it? The makeup is varied. You've got it's primarily white, but there's a few Hispanics. There's a few African Americans. But I could be wrong too. Some people seem like they may be biracial.
I heard a Jamaican accent in there. It was a beautiful voice. One of the jurors.
Yes,
that was wonderful.
Yes, and I love him, and I have a feeling that he may be picked. I really do. I have this gut feeling he's going to get picked because his answers were spot on.
Yeah, he thought about it, and I think he was a great juror. I think he's pretty fair. The sides, I think I've heard they have 10 strikes each.
Yeah, and I think Mr. J has 8 left.
So he's used a couple.
I can't remember. They both have used a couple. So, but some of them are already gone. But it's because the judge went wrong because they screwed up. You know what I'm saying? Like one doesn't even live in the county.
One doesn't live in the county. One watched the news the other day. Yeah. Well, it sounds like we have with this panel, this final panel, we have enough people that even if both sides used all their strikes, we're going to seat a jury. So
yeah, I think so.
We might be beginning with opening statements very shortly.
So, do you think, Scott? What did you just say again? We have enough of people.
There's enough people. They'll seat a jury. They won't have any problems completing the jury panel.
There's enough. There's enough of strikes on each side that even if they use them all, there's still enough of people to put a jury together.
She's talking to Joel from STS, Survive the Survivor, who's also there in court.
Yes,
awesome.
he's sitting next to me.
Without telling a whole bunch of details, did everything come through at the court for you, Jules? Did they get you taken care of today?
I don't know.
With the thing we talked about last night?
Yes, I knocked on the door, but I got no answer.
Okay.
So when I leave, when this is over, I'll knock on the door and see if somebody is there.
Awesome. All right. Well, thank you. Our feed's clipping in.
I will let you know. I will let you know ASAP on
Sounds
that.
good.
But it's so weird because I'm talking to you while I'm sitting in the jury box at the courtroom. It's really weird. One of your subs,
yeah,
and one of my Twitter followers, Callie, she's here today.
Awesome.
So that
awesome.
that was really nice.
Say hello to everyone for me. So, Jules, I'm gonna let you go back to being incognito here for a minute, and look forward to hearing a little more from you here. Maybe at the end of the day.
Do you want me to call you at the end of the day? You want me to call?
Yeah,
okay.
First check in the office and do all that stuff first, and then give us a call.
Will do.
Awesome.
Okay.
Thanks, Jules. Appreciate it. Bye.
No problem.
All right, Jules is calling us from the jury box. We're on break. It's all cool. We're all good. Jules is amazing. We met Jules when I met her when I went down to Florida for when we covered one of the Maya hearings after the Maya trial down in Sarasota. But we met her. I met her virtually before then, as we found out she was a court watcher, and met her through some of the other channels in this amazing community known as LawTube or LawTube adjacency. And Jules loves watching court, and so when she said she was going to be going here, we hooked up and she said she's going to be our eyes and ears. So she's telling us the stuff that is open to the public, but we just can't see on camera, and love the information that she provides for us. So thank you. And the other day she was even wearing our Recovery Addict hoodie. We made her a special hoodie as a thank you for what she did in the Maya trial with her name on it. I don't know if Brandy's there today. I think she's going to be there for court, but I'm not sure if she's there for jury selection. So let's see. We've got a few more minutes while this happened. Thoughts from you guys who haven't. First of all, let's do a quick show of hands. Let's do since they were asking questions, I'm going to ask questions. I figure that's my right. I'm going to do a quick poll because that's the best way to ask a question of y'all. Is this? I'm going to ask a better question than he did. Is this your? I know I can't mess it up. Okay, we're going to put a poll up in chat right now. The question is this your first time watching jury selection? Just a yes, no, because a lot of people watch court, but jury selection is generally not shown as often or watched as much. But it's very telling, and oftentimes it lays the foundation and explanation for why things happen the way they do in court. And it looks like we're almost 50-50 split right now, with about half of you. Yes, 45%. Okay, so of those 45% who this is the first time they've ever seen this, there is, in most of the country, there is an expectation or a tradition of jurors not being shown on screen, on video screen for when the trial is televised. But if you were to walk into any courtroom, which pretty much every courtroom and the public is allowed to walk into, if you're allowed to walk into a courtroom, you would be able to see and look at each of the jurors and see their faces and say, oh, I know, it's Bob. It's Bob from accounting. I wouldn't wave at them, but they are allowed to publicly be seen. There are some courtrooms where that tradition of we don't show the jurors on camera is not honored, and they literally will do the voir dire. They'll pick the jury with the jury sitting there in front of them, and those are fun jury selections to watch. This one, there's not as much to see because the jury pool is not mic'd very well, so it's hard to hear, and we don't get to see them, so it's not as interesting to watch. But you can tell from the questions that the lawyers ask. They're asking questions that are somewhat related to the case in some way. This is a normal process. This is how the system works. If you get called for jury selection, or you get called summons to serve on a jury, or potentially you show up for jury selection, you will sit in a panel like this assuming they don't seat a jury before they get to your number, because a lot of times that happens as well. But they'll sit you down, they'll ask you questions, and initially you'll fill out a form. It'll say, have you ever been convicted of a crime? And they'll list some of the crimes that may be involved in this. They'll ask sort of like generic questions. Is there anything that would prevent you from serving on the jury? Things like that. Those would all get you dismissed, possibly for cause. Not all of them, but some of them. Meaning that the court recognizes that because of your situation, your experience, or whatever you have going on in life right now, whether it's, I require dialysis X many times in this period of time. Well, that might be a little inconvenient to serve in court if that is your situation. So that would exempt you from court. You'd be dismissed for cause. Then there are other dismisses where each side gets to just strike people for whatever reason they choose. That's what's happening right now. The court has already established that these 50 some odd people who were sitting in the courtroom in Florida had passed all those for cause things. They didn't have, extenuating circumstances where I'm the only one at my job, and if I don't do my job, people die. Yes, sir, you'd be excused. They don't have those anymore. We're past that point. Now we're just trying to get rid of people where each side says, I just don't think he's going to be on our side, really. I don't think they're going to decide what I want them to decide, so I want to strike them, and they can do that. They have about 8 left each. So if we've got 46 jurors left or 48 jurors left, somewhere in that range, they need 6 jurors to deliberate, 8 jurors to be alternates. That takes up to 14. 8 strikes each. We still have leftovers. We are seating a jury out of that. So even if it takes all the time when we go through all those, we'll have a jury. Any questions about jury selection that we can answer or ask of someone who has been on the jury? Chris Wallace says, I've been on the jury. The voir dire was worse than the trial. It was terrible. Years ago, I went through the voir dire in a death penalty case. I was on pins and needles waiting to see if they seated me. Let's see. A lot of people saying we won't have opening statements today. I think the judge wants to get there, but it's going to be just shy of 4 o'clock when the jury's seated. So if it's opening statements, we would get opening statements, unless he puts a time limit on them. We'd only get one. I don't know. How are the leftovers chosen? It's generally by number. The lowest number that's not objected to or ruled out for cause, seated first, and you just pick the first 14 you get to. How was Rusty? Rusty was great. That was some good testimony. I was on the jury. The voir dire was super quick. Mostly just, do you know the defendant, any of the lawyers, or any of the cops involved? A lot of cases, voir dire can be done in 20 minutes. I mean, the judge's portion and both sides, each getting 10 minutes, and then you start the trial. These bigger cases take a little bit longer. Tracy Lynn George says, the last trial I was up as a potential juror in Canada was a university professor doing shady stuff. I wasn't selected. The defense attorney looked at the sheet and dismissed me. No questions. Something on there just didn't look right to him. Do they get snacks? Sean, I don't know. The judge will probably explain later on. Some courts feed the jury. It's rare nowadays to have courts sequester a jury. Sequester means they literally take the jury and put them up in a hotel and lock them up for the duration of the trial. It's almost like jail, only it's a bit nicer and no handcuffs. But it's rare to see a jury sequestered. Sometimes when we see it sequestered, it's going to be just during deliberations instead of just the whole trial. But generally, we see a split. Some courts will pay for the jurors' lunches, even take orders and bring the food in. Other courts will say, you're on your own, just get back here in time and don't talk to anyone while you're out on lunch. Delphi is sequestered, of course. That one is a crazy, crazy trial. The judge, I'm not a big fan of that. I'm a huge fan of transparency, and there is none in that case, like zero. How was Rusty's cross? Don't make me pick up the phone, says Debbie. It was spicy. It's worth rewatching. It really is. The Rusty's cross, we're talking about one of the witnesses in the Georgia versus Melody Ferris trial that we were watching this morning. Some judges will tell you that the jail makes great pork chops. We saw that as well. Pork chop day. The judge had some. How long is this case supposed to take? I believe we're at 2 to 3 weeks, or 3 to 4. So we're about a month, roughly. I trust a drunken bull before I trust Judge Gold. Is that like a saying that people say in his community? That's terrible. Jenny Robinson says, been helping select juries for 17 years. Always enjoy seeing how other states proceed. Delaware is quite different from many of the states I've watched coverage of. Every state's a little bit different. The process in general, your right to a trial is there. Your right to a trial by a jury of your peers is there. But the number of jurors that are there differs. How the jurors are selected differs a little bit, although the whole process has the voir dire. As far as, some do a random draw like bingo balls, and some, seat them randomly by whoever the computers spit them out, or however they arrived at the courthouse, like first one in, you're number 1, you're number 2. That's not used as much, because then you get people who really want to be jurors on the jury, and that's sometimes a bad thing. That's my own sayings, Ismail. It's a good one. 80s Music Man. I got summoned for jury duty years ago, but got doctor's note. I've not been summoned since. Some jurors raise chickens and bring everyone eggs, like in the Alex Murdaugh trial. Yeah. What we like, once the jury's selected, I think one of the most important things that we want to hear is the jury allowed to take notes? Will they be allowed to ask questions? And are they getting food? The food's just a curiosity thing. Notes, I think, is important. There are some states where they just flat out, no notes. Notes distract you from listening to what's happening at the time. And there are others that say, take really good notes, because that's what you're going to have to depend on. And you get everything in between. Then as far as the asking questions, we love trials where the jurors ask questions, because odds are somebody on the jury has the same question we're thinking of. Because prosecution didn't get the question answered from the witness. Defense didn't get it answered. It wasn't handled on, having a juror saying, but wait, what about? It's really telling. It puts you in the mind of the jury a little bit. It gives you a little bit of a peek inside how things are happening and what they're thinking about. So hopefully we get questions on this one. Down the docket, who is in the U.S. can't serve on a jury? You have to be a citizen. I believe convicted felons get a pass, a lifetime pass. Don't quote me on that. It might vary by state. I think they do. Kylie, member for 1 month, says, thank you, RA, for your awesome work on covering these trials. I appreciate everything you do. Cheers from Sydney, Australia. Kylie, thank you very much. You're staying up late watching this one. We're early. Let's see. Been a bailiff, says Jenny Robinson. Well, now we're a court security officer since 2008. I've seen a lot, but yep, here I am, soaking it up. Love this channel. Jenny, thank you so much. I love that you're here. And please, if you see something where your expertise would be useful, I do have a burner phone. We have a burner phone for the channel where you can call and you can text me and get information to you. If you got, hey, just for your information, this is what happens. The burner phone blows up nonstop, and I can't promise I'll respond to every message. I used to be able to, but I get hundreds a day now. But I do love to see and get updates and see dog pictures and everything else that you guys send me. Sarah T gifted a membership. Thank you, Sarah, for your generosity. It's early, 6:47 a.m. in Sydney, says Diane. Different places pay jurors differently. Yes, in Georgia, they were earning $35 a day. Some earn, we've heard, as little as like 12 or 8. And some don't even validate your parking. This one, $35 and validated parking. That's a pretty good deal. And you might even get free lunch. Do they choose randomly people to come? Usually they use a voter registration list, or they'll use like driver's license records of people who are also, well, I think, yeah, driver's license records are used sometimes as well. Somebody's calling in. Let's see who it is.
Call from
the Master Ayden.
Master Ayden, it's been a while since we talked. How are you doing?
I'm all right. I was just chiming into the whole how much you get paid a day, and I was so close to seeing Judge Boyd. She was only one floor above. I wasn't able to see it today.
Did you end up serving on the jury?
Okay, so what happened was we were all there, everybody got ready, and then I guess the defense had settled with the state. They settled their differences or made a plea deal or something.
Yeah,
last minute plea deal. So they dismissed everybody. I got my certificate, and they sent us home.
You got your get out of jury duty free certificate. That's
yeah,
awesome.
See, that's good for 3 years.
It would have been great to see you in one of Judge Boyd's trials.
I know. I told the lady that. I said, I watched her on YouTube. Because she seemed a little startled when I said that. I said, you know Judge Boyd? She's like, wait, how do you know Judge Boyd? I was like, she's all over YouTube. I watch her all the time. Recovery Addict. So she's like, oh, yeah, she is.
That's awesome. We sent her flowers a while back.
Oh,
last
nice,
year.
nice.
So.
Okay. I should have said that. Hey, yeah.
Master Ayden,
so,
thank
yeah,
you.
They were going to pay us $20 to start and $58 a day per our time there. That was the going rate for Bexar County jury.
Crazy. That's good money.
Yeah.
It's good money.
Yeah.
If you can make it.
Yeah.
It's not enough to live on.
True.
No, it's not a living wage. But for sitting around watching court, I'll take it. I'll take it.
Right. I wasn't able to see much of the trial. Have they started yet in Fairview? I know they were doing the selection process.
This is the last part of selection. Defense just finished. We're expecting them to do strikes right now, possibly some individual voir dire, but we're just about. We might get openings possibly today, more likely tomorrow morning, first thing.
Okay, for sure. I'll be listening to it at work. I wanted to try them in, but I'm not even allowed to have my phone at work. So y'all see me chatting, I'm sneaking on that. Don't tell my boss.
All right, we won't out you.
Okay,
Master Ayden, good talking to you.
Right.
Thanks, my friend.
You too, man.
We'll see you.
Bye.
He was almost serving on a jury in Judge Boyd's courtroom in San Antonio, Texas. That's a court we visit regularly. She's quite an interesting judge. A lot of fun to watch her.
CF 2603, State of Florida versus Sarah Boone. State.
Okay, sure, on behalf of the state.
Bless you. Defense.
James Owens for Sarah Boone. Tony Henderson for Sarah Boone.
We're doing introductions again.
Ms. Boone is seated at counsel's table, wearing the same clothing from this morning. All right.
The judge is missing. See what we're waiting for here. Jury questions are fantastic. Probably the best one we ever saw was the Maya trial. Maya was good. I think did they ask questions in Letitia Stout as well, out of Colorado? For some reason, I think we had that. Maya was interesting because we have a court feed being in the media that we could listen to but not share with you. And I have the ability to listen in one ear and repeat verbatim what I'm hearing live. And so I could listen in to the questions being discussed at the bench and share that with you. But I couldn't let you hear it directly. So I couldn't connect to the audio and let you play the audio. It was a lot of fun. Anyway, that was a crazy trial. Those questions were, wow. Those bus stop jurors, some of the best bus stop jurors you can find. I think they asked questions in the Treehouse murder trial. The new trial after the old one ended in mistrial. The new trial is coming up here soon. I think at the end of the year here. I think we're coming close. Debbie Brooks. Debbie, welcome to the gallery. Brand new member. Thank you so much, Debbie. We have a few Debbies here, but you can never have enough Debbies. At least that's my theory when we're talking about Little Debbie treats. They're delicious. Let's see. She fired 9 attorneys and she's angry, in my opinion. She looks a lot better than we've seen in previous days this week. Previous days there have been some heated exchanges. The gentleman she's talking to right now, that's her investigator, isn't it? Isn't that Billy Lane? Is that Billy Lane or is that Mr. Owens? I can't see. getting some dog pics on the burner phone. Let's see. Similicious OG gifted a membership, and that went to Alita Lay. Alita, congratulations. I met Alita when we were out in Utah at the Corey Richens trial. Thank you very much for welcoming me when we arrived there. That was awesome. Let's see. I think I missed a couple here just a minute ago. Let's see who we had. We had, let's see, Sarah T gifted a membership. Thank you, Sarah. We had Debbie Faison Cook gifted a membership, or maybe two. I'm not sure. It might have just registered twice. Debbie Brooks, welcome to the gallery. And Similicious OG, thank you. Thank you, my friend. Welcome. All right, I'm gonna end this poll, the jury selection poll. We've had just about 1,000 votes. 929, I think, was the final count. 930. 43% say first time watching jury selection. Some of the courts that you're going to like watching jury selection on, Thurston, Washington. We're talking Lacey County, Washington, the state of Washington, not Washington, D.C., obviously. They always show jury selection, and that court is a hoot.
Parties are going to continue reviewing their notes before we proceed with selection in this matter. As addressed at the bench, we will begin with jurors seated in seat 1. The state will have the opportunity to accept or reject those persons seated in odd seats. Then it will proceed to the defense for all even seats to accept or reject. Both parties have 10 preemptory challenges for the purposes of selecting our panel of 6. Once we have that panel of 6, backstrikes will be permitted. If there are no backstrikes, we will then proceed with selecting as many alternates as possible. When the parties are ready to proceed with selection, please let me know. We'll be off the record until that time.
All right, there's the process. That's how it's going to go. We'll get to hear it happening as they call out numbers. We won't hear the reasonings. The judge will just say, "Are you going to use a strike, preemptory strike? Yes or no?" And if one side says yes, that's it. They lose. It's just like throwing calling timeout in a football game. You lose a timeout, but you get the timeout. It doesn't matter. You can't challenge someone's timeout. Elijah says, it only took me 30 minutes to figure out how to explain voir dire, or voir dire, depending on how you pronounce it, and for English speakers. For those interested, voir dire is pronounced voir dire. There we go. I've heard lawyers and even judges just do it both ways. So I will get it wrong every time, though. I can promise you that. What does backstrike mean? I think when they finish and they seat the panel, they basically say, now that we have them seated, are there any you want to go back and remove if you have any extra strikes? So I think they get like 2 chances to remove people once they have the panel seated. Each side has a 50% chance to get rid of the ones they want. It was a weird, even an odd thing I've never seen before. That's new. Dreamscape. It was only just over a month ago, well, a little over a month ago, I think, that we had Sarah Boone facing pro se trial, where she would be doing this all on her own. And can you imagine the circus that would have ensued if she would have been the one doing this jury selection? Every question she asked would have been probably objected to and sustained. It's just you need to understand the law to work through this process. So I think she is happy that she has a team of lawyers supporting her. She's very happy to be out of the jail clothes. And she's, as far as we know, completely unrestrained. When she left the courtroom yesterday, we saw that she was not shackled on the ankles, and she's only handcuffed with a belly chain when she's transported on brakes, and that's done outside the presence of the jury. So she will not have any appearance of being in custody, although the jury they may glean that she is aware that they are, just from the bailiffs and everything else, that she is in custody. What does she keep writing? Oh, Barb. Sarah Boone is a writer. She is very, very good at writing and taking notes. Some of her letters have been very, very long. We've read all the letters that she sent to the judge thus far in this many-year saga. But she takes a lot of notes. She communicates with her lawyers a lot, and she remembers things she doesn't like, and she writes it down. Stephanie Wiley, brand new member. Welcome to the gallery. There we go. Backstrike is a peremptory challenge used to strike a prospective juror after the juror has been accepted onto the jury panel, but before the panel has been sworn. So you get two. Yeah, they're going to be able to get rid of anyone they don't want. She is unnecessarily verbose, in my opinion. You remember the letter where she like sent the Sarah Boone's trial terms, her law vocabulary book, where she just was copy and pasting definitions of words? I think she ran out of things to say in that letter. Sarah Boone's going to write a book unless they prevent her from doing so. Laurie, this is a great point. The laws you're talking about that prevent criminals from making money, I believe they're called Son of Sam laws. That's a lot what we refer to it as. Those have been struck down in large part, pretty much across the U.S. And they, victims, yeah, they're upset, but there's a freedom of speech that doesn't necessarily go away. It depends on the state how that's viewed. Maybe a portion of their revenue can be taken, but they can't take all the money. Iris gifted a membership. Thank you, Iris. That one went to Priscilla. Let's see. The person that's next to her on her side, that is Mr. Henderson's, I believe, daughter, the one that just passed the bar that's assisting on this case. Is this Florida? Yes, it is. Orlando, Florida, Orange County. Some states prevent media deals. Yes, some states prevent you talking to the media, period. Like to make media statements and things like that for deals like that. Let's see. In Delaware, attorneys can't strike after consent. Only jurors that can be stricken are jurors that sat since they were content. What was it? Content. But striking after being content calls for a sidebar. You can always count on Florida to do something different. Susan Smith just got disciplined for talking to the media. Yeah, Nana, I wish that we've had this before. I think we've got the same cameraman. I think we've got the Maya trial cameraman, and I don't want to say anything bad about him, but because I know we've got people that are friends there, but this particular cameraman is really good at close-ups. Sarah practically quoted the entire U.S. Constitution to the judge. I thought she was going to write the whole Magna Carta at one time. Can we do a poll on who thinks Sarah's going to fire her lawyers mid-trial? I don't think the judge will let her at this point. Because of where we are, there would have to be something pretty major where the judge could not let it proceed. Because the judge would basically at that point, as he has before, he said, you're stalling. This is a stalling tactic to delay trial. And I think he'd call it as a stall and say, no, we're not going to allow that because it's, no. This is going forward. You can't stop it like that. Plus, I think she's really happy her lawyers are listening to her. They're dedicated to her case. I mean, they've flown out from other states to be there. Can't see. I'm covering people up. Sorry. They have like her and no other cases. Let me check mod chat just 1 second. I appreciate everyone who's here in the channel. I realize there's some people who've chosen to support the channel financially, and to them I would say thank you so much. It's what makes it possible, honestly. But if you're not in that situation and you're just here because you love court, I would also say thank you so much. Please, just thank you for being here. I would ask that if you want to show appreciation and aren't in a position where financial support would work, just click the like button. That's all we ask. YouTube will do the rest from there. And appreciate it. You guys you're all amazing. And you don't have to be a member, by the way. You don't have to be a member to ask a question or to get something said. Now, as soon as I say this, it's going to go nuts in chat. But just tagging me in a message saying, hey, at Recovery Addict, what about this? And asking a question, that's great. I would ask that you try to keep it relevant to what we're talking about here instead of just every comment. There are a lot of conversations that we have in chat that might not be relevant to the case. But tagging me with a question is the best way for me to see it. And let's see, somebody like this one, Samantha Terry says, hey, please see mod chat. It shows up in orange on my side, so it just jumps off the page for me. So if you do have a question or something, obviously I know a super chat does sort of rise to the top automatically through YouTube. But if you have a question, you could just tag me, and that will get to me as well. Julie says, I've been here since the Zachary Anderson trial. That was an amazing trial. That was the first trial that the judge, it's the only trial the judges played our live stream in during court, which is crazy. That's when we do our intro in the morning. I'll play it here because we have nothing else going on. This soundbite after my voice was the recording from the judge after he played our stream in court. 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom. The fireworks are not done.
Now we're getting commentary on the case.
Yeah, the fireworks are not done. That was the sound coming off over his speakers during the live stream, during that trial. The jury's walking in, and he's playing our live stream in court over the speakers. It was wild. It was wild.
Okay. Technological difficulties here. All right, we're back on the record. Case number 2020, CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Suitcase on behalf of the state. Who are you, Jay?
Defense.
James Owens for Miss Boone.
Kevin Beck on behalf of Sarah Boone.
All right, thank you very much. The state is advised to the juror members that they would like to follow up with 40, 49, and 51.
40's coming
Defense,
back.
do you have any juror members that you would like to follow up with other than 13?
Dodie, the judge will tell us tonight.
All right. Let's go ahead and bring in juror in seat 40 wearing badge 201, and we'll stand when that juror enters.
Curtis, thank you very much. 17 months. Ohio Gin, 21 months. The furnace is fixed now. They fixed it. We had to replace the control board.
Yeah.
Rachel B. gifted a membership. Thank you very much. Katie Bug gifted a membership. Thank you for your generosity. It's going to good people. 40 is the one who just didn't like the defense.
Thank you so much, juror number 40, for coming back in. We've got a couple of follow-up questions to ask of you. State, you may proceed.
Okay, Jason.
State, you may proceed. Thank you.
Ma'am, I believe towards the end of Mr. Henderson's questioning, there was a question about potentially feeling uncomfortable or something to that effect.
Yes, so it was mostly because of the time. I have to be at pickup of my kids by 6. And if, like yesterday, I made it at 5:59. So if at any point we go over 5, then I would not be able to make it on time.
Okay. No follow-up, thank you.
Any follow-up?
No, Your Honor.
All right. Thank you, ma'am.
Thanks.
Okay, so she doesn't just dislike the defense. She misunderstood the question. Next juror. It's just one juror at a
State
time.
any position with regard to juror in seat 40 at this time.
For cause, they say.
Juror in seat 40 wearing badge 201 will be stricken for cause by way of stipulation. Let's bring in juror in seat 49 wearing badge 192.
Everyone will stand when the juror comes in. There's a gift setting you can turn on.
Thank you. Everybody can be seated. Juror number 49, good afternoon, sir. We just had some follow-up questions to ask of you, okay? State, you may proceed.
Sir, I believe at some point during questioning there was a point in time where you indicated you'd like to speak without the other jurors present, am I correct?
I did, but to be honest, I can't recall the purpose.
Yeah, everything's on.
We're not hearing the microphone.
My apologies. I did say that, and I don't recall in what respect that was to, other than my comment late yesterday afternoon.
Did it have anything to do with a friend being murdered, potentially?
My brother.
Your brother, okay. And more details you wanted to share in private, or?
I just wanted to make sure that I wasn't omitting anything as we were discussing everything, or as you were asking the questions. It happened so long ago that I didn't really bring it up at the correct time. I just wanted to make sure that everybody knew.
So he has to speak outside the presence of the rest of the jury.
That you went through and the rest of your family went through. That experience that you and your family and his loved ones and friends all went through with his loss, is that going to affect your ability to be fair and impartial in a murder trial? As opposed to, there's lots of other trials you could have done. You're going to be excused today if you don't make this one. They're not going to make you do another trial, but are you?
I'm not concerned with my ability for jury status. I do not believe that it will influence me because it was 30 odd years ago.
Thank you.
Defense?
Any follow-up?
No follow-up.
Okay. Thank you, sir. I appreciate you.
Laura Kay, thank you. 16 months. This case took so long to get this far. It's been forever. And Sarah Boone feels every single bit of those days. She's been counting them. It's a malicious OG. Love this community and the mods.
State
Are
any
the best.
position as to the juror in seat 49.
No motions.
Defense?
No.
Okay, thank you. Let's remain standing. We'll bring in the juror in seat 51 wearing badge 325, excuse me.
Okay, so the no motion on that one means that juror is still fair game and could be selected. Thank you for the kind words, Stephanie.
Y'all can be seated. Thank you. All right, juror number 51, good afternoon. We wanted to bring you in because we had some specific questions to ask of you. State, you may proceed.
Okay.
Good afternoon, ma'am. Was there a certain point in time during questioning that you indicated that you wanted to speak to us without the company of the
There
other jurors?
was, and I think it had to do with, it was the personality, mental stuff. Our daughter has had a lot of physical and mental health problems, has been diagnosed with multiple medical or mental illnesses. At one point, she was diagnosed with a borderline personality disorder, which I think they decided that wasn't it. So she's just had multiple diagnoses. I think that's the question that you had wanted clarified, and I think there may have been something else. If so, I can't remember.
That was my one note. And so my question is, potentially in this trial, there might be testimony about disorders that are recognized by the DSM-5TR, which is what your daughter would be diagnosed from.
Mm-hmm.
If there's testimony about that, either by civilians or by expert witnesses, is that going to present a problem for you to sit and fairly and impartially decide that testimony and evidence that you hear and see how it applies to this case and to this defendant and this decedent?
I don't think my experience with my daughter would influence me. I think mental disorders can be complicated, though.
Okay.
So.
All right, and so just to phrase it a different way without going into the airplane ticket scenario that we use, and we use that in every trial. Do you have any doubt in your ability to be fair and impartial if you hear that sort of testimony and evidence?
No, I do not.
All right, thank you.
Okay.
The
defense, any follow-up?
The lawyers asking the questions aren't standing at the mics. But
you just leave the microphone right in the seat next to you. Thank you.
Okay, I think we're ready to select the jury then. That should be the last one. Do they have any other jurors to
State
bring
any
in?
motion with regard to juror in seat 51?
No, Your Honor.
Defense?
No, Your Honor.
All right, let's remain standing and we'll bring in the juror in seat 13 wearing badge 2130.
13. This one the defense wanted to bring in. Defense has a question about this one. I'll try to crank the audio here so we can hear the question. Of course, the judge is going to be really loud, as will the defendant. I love that he's having everybody stand for one juror.
Juror number 13, good afternoon, ma'am. We just had some additional follow-up questions to ask of you. Mr. Henderson, you may proceed, sir.
Good afternoon, ma'am.
Hi.
She's nervous.
I'll speak up.
Podium. Yeah, podium's right here, Mr. Henderson, front center.
Thank you.
Good afternoon, ma'am.
Hello.
I believe it was yesterday when it came up, but you said that you're going to be testifying in a case.
Yes, sir.
Is that correct?
Yes,
Could
sir.
you tell me what case that is?
It's a case, the state against my ex-husband for a domestic battery charge.
All right. Are you the alleged victim in that case?
Yes, sir.
All right. Due to the nature of this case and what you've heard in the questioning, do you think you can be fair and impartial?
I think so, yes.
Excuse me?
Yes.
Okay. Do you feel... What's your relationship with the state attorney's office now?
I don't have one.
Okay.
They're trying
do
to
you
get her struck
feel
for cause.
because they are representing you, well, not really you, they're representing the state, but you're the victim in the case. Does that give you any feeling that you have allegiance with them or anything like that?
No, I would hope that this would have no impact. I would assume so.
All right. Thank you, ma'am. I don't have any further questions.
They wanted a for cause reason. They don't
Any
have
follow-up?
it. They'll have to use
Thank
a
you,
strike
ma'am.
on her because they do not want her to serve. She's a victim of domestic violence. The defense would not want her on the panel. Sloth Life, thanks for gifting a membership.
State any motions with regard to juror in seat 13?
No, Your Honor.
Defense? Okay, all right. You all can be seated. Thank you.
The key was she said she could be fair and impartial. That means that she could be a juror. But let's see
Are
if
there
she
any
actually gets
additional
on the jury.
cause challenges on behalf of the state?
If she's not on the jury, it's because defense
Yes, sir.
struck her.
May I remain seated?
Yes, sir.
Seat 2.
Response?
Stipulate.
Juror in seat 2 wearing badge 651 will be stricken for cause by way of stipulation.
Seat 22.
Stipulate.
Juror in seat 22 wearing badge 13 will be stricken for cause by way of stipulation.
Seat 34.
I'm sorry?
34.
Stipulate.
Juror in seat 34 wearing badge 310 will be stricken for cause by way of stipulation.
They're both agreeing that these jurors need to go. So no strikes have been used yet.
44.
Stipulate.
Juror in seat 44 wearing badge 506 will be stricken for cause by way of stipulation.
Seat 48.
Stipulate.
Juror in seat 48 wearing badge 4045 will be stricken for cause by way of stipulation.
No additionals.
Any additional cause challenges on behalf of the defense?
No, Your Honor.
Okay, all right. I believe that leaves us with 38 potential jurors remaining, if my math is correct.
That's just
We will
enough.
begin with selection at this point in time, starting with seat number 1. State, acceptable?
Judge, excuse me. Can we make some seating arrangements because I have to reseat because I'm
Sure.
gonna have to.
If you need to move, go ahead, sir.
Yeah.
Drag your chair over there. The binder moves. All the attorneys and the paralegals and everything are all going to be on the same desk. They've got a big seating chart. It looks like a calendar where they have the marks, probably colored pencils or highlighters of who they like on the jury, who they don't want on the jury. All the stipulations have been for cause, so we're done with for cause now. Every other strike from now on.
All right. Starting with seat number 1. State, acceptable?
Acceptable.
Defense?
Acceptable.
Seat number 2 was previously struck for cause by way of stipulation. 3. State?
Acceptable.
Defense?
Acceptable.
There's 2.
4. Defense? State?
First peremptory.
Any response,
struck.
defense? Any response to the peremptory challenge as to juror in seat 4? So stricken.
Our response.
Seat 5.
Acceptable.
Defense?
Acceptable.
We've got 3.
6. Defense?
It's the number of jurors we've got seated so far.
State?
Acceptable.
7. State?
Acceptable.
Defense?
Preempt.
Any response, state?
No, sir.
That will be juror number 7 wearing badge 380 will be struck by virtue of the defense's first peremptory. 8. Defense? State?
Second peremptory.
Any response?
None.
Juror in seat 8 wearing badge 361 will be struck by virtue of the state's second peremptory. 9.
Acceptable.
State?
I'm sorry, acceptable.
That's fine. Appreciate you.
It's alternating.
Defense?
Like they're going back and forth. State goes
10.
first, then defense.
10 and 11 were previously struck by way of stipulation for cause. 12. Defense? Any response?
No, sir.
Juror in seat 12 wearing badge 837 has been struck by virtue of the defense's second peremptory. 13. State?
Acceptable.
Acceptable.
Defense?
Preempt.
Acceptable.
She stayed.
I believe that we have a panel. Our panel currently is jurors in seats 1, 3, 5, 6, 9, and 13. Any backstrikes? State.
Seat 6.
Any response?
The audio is off.
No response.
Juror in seat 6 will be struck by virtue of the state's third peremptory. Any additional backstrikes? State.
No, sir.
Any additional backstrikes? Defense.
No, Your Honor.
Okay, those are our 6. Those are our main jurors.
Picking up on 14. Defense.
Now we need alternates.
Preempt.
Any response?
No, sir. So that's alternate strike 1.
We don't have a panel, sir.
Oh, I thought we had 6.
No, we had 6. Currently have 1, 3, 5, 9, and 13.
Acceptable. Sorry, no objection to their peremptory. I guess that's...
Juror number 14, wearing
Still
badge
5.
537, will be struck by virtue of the defense's third peremptory challenge. 15, state.
Acceptable.
Defense.
Acceptable.
Now we have a panel.
Believe that we have a panel. Our panel currently is 1, 3, 5, 9, 13, and 15. Any backstrikes, state?
No, sir.
Any backstrikes, defense?
Need to confer with my client.
You may.
Now, Sarah Boone is weighing in to see if she likes any of those. We might see a backstrike on 13. I'll see if I can fix the audio here. I'm not sure why it's out of sync. We have a panel again. We still have to pick alternates, but they have fewer strikes in the alternate selection process. Oh, we're on. Hang on. I know what I did. Should be right here. Where's our audio? I jumped back in time. That's what threw us off. I was watching our replay, which is a few seconds behind.
Judge, at this time, the defense would like to use a peremptory on juror number 1.
Juror number 1.
Any response, state?
No, Your Honor.
Juror in seat 1, wearing badge 134, has been struck by virtue of the defense's 4th peremptory. Any other additional backstrikes?
No, Your Honor.
Any additional backstrikes, state?
No, sir.
All right, picking up with 16. Defense.
Acceptable.
State?
Acceptable.
I believe we have a panel.
Back to a panel.
Panel is 3, 5, 9, 13, 15, and 16. Any backstrikes, state?
No, sir.
Any backstrikes, defense?
Judge, could you read the panel?
I can, sir. 3, 5, 9, 13, 15, and 16. Yes, sir. Of course.
Now they're seeing if they like this makeup. Once they've seen the whole panel together, do they like that mix? They can use backstrikes as long as they still have preemptive challenges left. This is like watching a ping pong match at the Olympics. It's going so fast. The judge, he's talking fast. I think he wants to start openings tonight. I really do. Realize this case already got delayed because of the hurricane. We were supposed to start this last week. At that time, the judge thought that we would have a panel.
Exercise of backstrikes on juror number 3.
Any response, state?
No, sir.
They just stuck.
Juror number 3, wearing badge 899, has been struck by virtue of the defense's 5th preemptory. Any other additional backstrikes?
Now we're down to 5 again.
Defense?
No, Your Honor.
State? Yes, sir.
How many strikes do you have in defense?
You've used 5. Any other additional backstrikes, state?
No, Your Honor.
Picking up on 17. State?
Acceptable.
Defense?
Acceptable.
I believe we have a panel again. Jurors 5.
Sorry, Judge.
Yes, sir.
I need to go back on 17, so we are going to use a preempt on juror 17.
Any response?
No, sir.
Juror in seat 17, wearing badge 57, will be struck by virtue of the defense's 6th preemptory challenge.
What is the
18.
game they're playing here?
Defense. State?
4th peremptory.
State.
Any
struck
response,
18.
defense?
None.
Juror number 18, wearing badge 7, struck by virtue of the state's 4th preemptory challenge. 19. State.
Acceptable.
Defense.
Preempt.
Any response?
No, sir.
Juror number 19, wearing badge 891, will be struck by virtue of the defense's 7th preemptory. 20 was previously struck for cause. 21.
Acceptable.
Acceptable.
Okay, we have a panel again.
Believe that we have a panel. Panel is 5, 9, 13, 15, 16, 21. Any backstrikes, state?
No, sir.
Any backstrikes, defense? The first, of course.
This is an amazing process. I've never seen this played out. Usually this is done at the bench. And I've never seen it with backstrikes either, which just adds a new level to this chess match.
Okay.
None.
Our jury panel will be jurors seats 5, 9, 13, 15, 16, and 21. We will now proceed with selecting any alternates. Yes, sir.
Did you announce the jury?
I can't, sir. 5, 9, 13, 15, 16, 21.
Any strikes now?
Thank you. Juror number 22 was previously struck for cause, 23 for an alternate position. State.
Acceptable.
Acceptable.
Okay. Juror number 23 will be serving as our first alternate. Moving to juror in seat 24. Defense. Any response?
No, sir.
Juror number 24, wearing badge 235, will be stricken by virtue of the defense's 8th preemptory challenge.
I'd like to see a
25
response.
was previously struck for cause. 26. Defense.
I have a question on the process. We're at the alternates now.
Correct, sir.
So at this point in time, it starts over because we have alternate challenges. Is that correct?
Yeah, the way I marked his down was as defense alternate 2 strike, just because it was our second alternate, but we should have as many alternate strikes as we seat alternates is what I believe our agreement is.
All right, that's fine by me. All right.
Wow.
I thought I only have one alternate strike.
Well, but I just marked it as, because we're shooting for alternate number 2, so I'm just trying to keep track of that but
I understand what you're saying. So I've used one alternate strike.
yes, sir.
That's correct.
All right, I'm ready to
25 was previously struck for cause. 26. Defense.
Graham.
Any response?
No, sir.
26, wearing badge 165, will be the defense's second alternate preemptory. '27, state.
Acceptable.
Defense?
acceptable.
Juror number 27 will be our second alternate. 28, defense.
Acceptable.
State. Acceptable. Juror number 28 will be our third alternate. 29.
Acceptable.
That's the state's call. It's odd.
I'll use an alternate strike.
I wonder if they
response,
used a
defense?
strike only because they said acceptable.
Juror number 29 will be struck by virtue of the state's first alternate strike.
I've lost place on where
30
we're
was previously struck for cause by way of stipulation. 31, state.
Acceptable.
Defense. Any response?
No, sir.
Juror number 31 will be struck by virtue of the defense's third alternative strike. 32, defense.
Acceptable.
Acceptable.
32 will serve as our fourth alternate. 33.
Who's it on?
State. It's odd.
Acceptable.
Defense.
Acceptable.
All right, 33 will serve as our sixth alternate.
Fifth.
I'm sorry, I'm one ahead. I already wrote it in for 5. I apologize. 34 was previously struck for cause. 35. State.
Acceptable.
Defense. Juror 35 will be our sixth alternate. 36, defense.
No response.
Juror in seat 36 will be struck by virtue of the defense's fourth alternate strike. 37.
Acceptable.
Defense. Acceptable. 37 will serve as our seventh alternate. 38. Defense.
Acceptable.
State.
Acceptable.
Going for 8. There's our 8th. Any back
We have an
strikes?
alternate panel, a total of 14. Our alternates are 23, 27, 28, 32, 33, 35, 37, and 38. Any back strikes, state.
Seat 35, alternate strike number 2 for the state.
Any response?
I mean, I'm not 30. Did I say 35?
You said 35, yes, sir.
33.
Okay. All right, juror in seat 33 will be the state's second alternate strike. Any additional back strikes, state?
Not at this time.
Any additional back strikes, defense?
No.
39 and 40 were previously struck for cause by stipulation. 41, state.
Acceptable.
Any response?
No, sir.
All right, juror number 41, wearing badge 76, has been struck by virtue of the defense's fifth alternate challenge. 42 was previously struck for cause by way of stipulation. 43, state.
Acceptable.
Defense.
Acceptable.
I believe that we have our alternates. Our alternates at this time are 23, 27, 28, 32, 35, 37, 38, and 43. Any back strikes, state.
No back strikes to the original panel or the 8 alternates.
Defense. Any back strikes? Yes, sir.
Judge, we're satisfied as to both the original panel and alternate.
Okay. So our alternates in this case will be juror in seat 23, 27, 28, 32, 35, 37, 38, and 43.
State accepts the panel.
Defense, do you accept the panel? Yes, sir.
They're inquiring with Sarah, see if she's good with that. Martha, I'm excited. I'm like,
okay, very good.
We're done. We've got a jury.
Can the parties approach for a moment?
We have a jury. Now we're talking logistics. This is what the judge is looking at. He's looking at the clock. He's saying it's 4:38 right now. I want the jury to be able to go home at a reasonable time. How long are openings? Do you want me to instruct to the jury and then come back and do opens in the morning? I think we're going to get something tonight. Just not sure exactly what. Petrified. I don't know why 13 made it on. That's interesting. Hang on 1 second. Blackbird, I see you calling here. I just need to let the phone connect.
Call from. Really quick.
Real quick, Blackbird, go ahead.
If the defense would have stricken 13 or the DV, wouldn't that have undermined their case theory of battered spouse?
Here's the problem. There's two thoughts. You could say, yes, she's going to relate to Sarah Boone, or she's going to look at Sarah Boone and say, no, that's not what it is. I've been there.
I know.
So it could go either way. And I thought, why risk it? Because that's a strong opinion.
No, they definitely strike. Okay, you can let me go, but I just wanted to say that.
Thanks a lot.
Thanks. Bye.
We'll see you. Bye. Great call. Miranda, thank you. Thank you for the super sticker. I see you're here. We'll mark you present.
Ms. Boone, good afternoon, ma'am. I have a couple of things to go over with you before we bring in our panel. You were previously sworn this morning. You've been present throughout the entire jury selection process that began on Monday. You've been seated at counsel's table either here in 23 Alpha or 12 Alpha of the Orange County Courthouse, and you've been able to observe the jurors during that entire process. Were you able to hear the questions asked of the jurors and their responses?
Yes.
Did you confer with your counsel about who you wanted or did not want to be selected for your jury?
I did.
Do you believe you were given a meaningful opportunity to participate?
Yes.
Is there anyone that you wanted to keep that your lawyers struck?
No.
Are you satisfied with your attorney's performances so far in this trial?
Absolutely.
Do you agree with the panel that has been selected for your case?
Absolutely.
Is there anything you would like to bring to my attention at this time?
I would like snacks.
No, thank you very much.
When the court reads the 2.1 preliminary instruction defense, would you like me to read the defendant's right to remain silent section of same to our panel?
Yes, Your Honor.
All right, thank you very much.
Right to remain silent. Are they switching up? Because you can't do battered spouse unless she lays the foundation, which she has not done yet. The judge ruled on that already. All right.
Bring our panel in. State.
There's.
No, Your Honor.
Defense.
No, Your Honor.
Okay. Let's go ahead and bring back in our panel. We will stand. Madam Clerk will identify them by their badge number. I will ask them to remain seated where they are, and then we'll excuse the balance of the panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1a note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel.
Opening tomorrow.
You will bring the jury.
Thank you. Thank you, Judge. You may bring the jury.
Thank you.
So we got openings tomorrow morning. Fun fact, tomorrow afternoon, actually at noon, I'm headed to South Carolina to help with the emergency cleanup procedures down there. I'm in a volunteer crew of altogether about 6,000 or 7,000 people in our organization that will be providing service throughout all of Florida, all the way up through Virginia. We're going to have this live stream live, but there will be a point where I disappear and you will just get the court feed directly without me on it. And we have to say thank you to Trial TV Live, who is running our equipment down there at the courthouse right now to bring us this. A lot of other stations decided not to air this, but we thought this would be worth watching. So if you want to watch the trial here, we are covering it gavel to gavel throughout the duration of the trial. So now's a great time to hit the subscribe button if you haven't. Peter Ware gifted 5 memberships. There's another reason to be here. We've got an amazing community that's very generous. Thank you, Peter, for your generous donation of 5 memberships. And congratulations to the winner. Gonna let you watch unsupervised. We're gonna have mods here with the ban hammer out in force. It's all right. You guys will be good. Boone is happy. She's wanted her day in court for years, and now she's getting it. Today's the day. Podcast tonight. Yes, we will be on for the podcast tonight.
State, do you recognize our panel?
Yes, sir.
Defense, do you recognize our panel?
Yes, Your Honor.
I thank you. All can be seated. Members of our panel, we have been able to select a jury to serve in this case. Madam Clerk is going to call you out by your badge number, not the paddle number that you've been using all yesterday and today. Please stay in your seats when your badge number is called. Madam Clerk?
Juror number 295. Juror number, you want them to stand? So.
Please, if you could stand when your badge number is called, please. Thank you.
Thanks, Lynn.
Juror number 9. Remain standing. Juror number 569. Juror number 515. Juror number 130. Juror number 249. 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. And juror number 102.
State, do you recognize the jury is selected?
Yes, Your Honor.
Defense, do you recognize the jury is selected? Bless you.
The judge is going to say that every single time throughout this trial.
All right. Thank you.
Bless you. Maybe that's what we need to count. The
You all
bless,
can be seated.
the bless
Thank
you
very
count.
much. To the members of our panel that were not selected, I thank you so much for your time and your participation and your attention in this very important process. You have my thanks, the thanks of the lawyers, and the thanks of Ms. Boone. It is entirely up to you whether or not you would like to discuss this case. You may do so, or you may decline. That privilege is yours. Please proceed now back to the jury assembly room, where they will validate your parking, provide you your jury certificates, and give you further directions. Thank you, God bless you, and have a great rest of the week.
The people who get to leave get to discuss the case. The jurors that stay do not get to discuss the case. Debbie, thanks for the suggestion. The chat's been pretty busy. I've missed a lot of comments.
Please don't go anywhere.
Seated jurors, please stay.
Mary, do the call one more time. Okay. Please.
Do the call, the list one more time. Make sure we got everybody.
I'm just going to do a roll call.
Y'all can be seated. Thank you.
Just going to do a roll call. You don't have to stand, just raise your hand. Juror number 295. Juror number 9. Juror number 569. Juror number 515. Juror number 130. Juror number 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. Juror number 102.
All right. Thank you. All right. Members of our jury, I have a couple of instructions to read to you. Oh, yes. Madam Clerk needs to swear you in. So if you could please stand up, raise your hands, please.
Do you swear or affirm to truly try the issues between the state of Florida and the defense and render a true verdict according to the law and evidence, so help you God?
Thank you all very much. You can be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Sarah Boone. This is a criminal case. Ms. Boone is charged with murder. The definition of the crime charged will be explained to you later. The state's charging document, which is called an information, is not evidence, and it is not to be considered by you as proof of any guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Ms. Boone in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. End of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. The contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted as so to consume as little of your time as necessary for a fair and orderly trial of the case. Members of our jury have one additional instruction to read to you regarding note-taking. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. With that, members of the jury, we will pick up tomorrow morning in courtroom 12A of the Orange County Courthouse, and we will begin with opening statements at that time. I instruct you to follow the instructions that I've just read to you, including not reading any newspapers or watching the local news, having any conversations with anyone, or conducting any independent research or investigation as to the persons, places, things, and charge in this case. With that, again, I thank you for your service, and we will see you in 12 Alpha tomorrow morning at 9 a.m.
All right. They say 9 a.m. If the jury shows up at 9, hopefully they'll be here a little earlier than that. Oops, wrong button. I'm sorry. That's what I need. So that wasn't the full... Oh. No, there's no ring. What do we look... Cameron, what are we... We're getting B-roll? I don't know what that was about.
May the parties approach for one moment.
All right, it's our intent to cover this trial gavel to gavel. That's why we have reporters in the courtroom. We have equipment on the scene, and we are broadcasting this live through our own electronics with the help of an amazing dynamic duo at Trial TV Live. Thank you very much, Chris and Aaron. They're our personnel down there. Well, Chris is down there on the scene running the electronics, and I think we've got everything figured out to make it nice and smooth that way. Appreciate him for all that. So what's going to happen tomorrow is we're going to follow this case, gavel to gavel. We're going to start the live stream. I'll be here a little bit in the morning, and then I'm going to disappear because I'll be driving down to South Carolina to help cut up trees and tarp roofs and things like that. And I'll be down there Saturday and Sunday. I'll come back Sunday night, excuse me. And then we're going to continue this on Monday. We might do some catch up in the evenings on the fire trial, on what we call the Mountain Dew murder, which is Georgia versus Melody Ferris. So if we're up to that, we might try to catch up and follow that trial to its conclusion, because I think it's about to finish the state's case. If they haven't,
Mr. Owens, once you've had that conversation with her, just let me know.
Quick conversation there. So I'm texting right now with my coordinator. What we're gonna do is make sure all this live stream is working properly, and then we'll just have it. It will look like this all day. It'll be this channel. We'll still have it'll be here on Recovery Addict, even though we're streaming this through Top Mark Media. That's an unlisted. It's unlisted over there, and I'm showing it here instead. So anyway, so we're going to be back here. If you want to watch it here, if you want to watch the whole trial here, I welcome you. Please, we'd love you to be here. Please just remember, we're a friendly group here. We're all friends, even if we disagree at the end of the day. It's friends first, and we just ask you to be respectful to the people who we see on the screen and to the people
with my
we
client
meet
about the issue
chat.
on cross-examination of her ex-husband Brian Boone about the family law case, the dissolution of marriage case, and through my cross, if I explore those issues, it may come out that she's been in jail pending her arrest back in February the 24th of 2020, so 4.5 years. She understands that may open the door. It may come out. She understands that I have to make a decision about whether to explore that area of cross-examination, but I believe she's going to say that she trusts my judgment. She is concerned about it coming out that she's had 8 prior attorneys. She does not want that coming out, but that's her biggest concern.
Okay. We'll address that in just a moment.
I'm sorry.
Ma'am,
Hang on.
I don't want to go into the specifics of any conversation that you've had with any of your attorneys on that issue. I just need to know whether or not you've had those conversations, okay? Is what your lawyer just represented accurate as the conversation that you've had as to that issue regarding cross-examining your former husband, Brian Boone?
Yes.
Okay. Do you understand the risks that if he seeks to impeach or call into question the bias and credibility of your former husband, Mr. Boone, as to what has transpired in your dissolution of marriage case, it may open the door to the fact that you have been incarcerated since February of 2020?
Yes.
Are you in agreement with that strategy, understanding those risks?
I am.
Okay. Now, with regard to your concern, ma'am, over having 8 prior attorneys, I don't intend on allowing it. I'm sure that's not part of the state's case in chief.
No, Your Honor, I don't see how it would possibly become relevant, but if we somehow believed it did, we would certainly have a sidebar before anything about that?
If by some circumstance that somehow becomes relevant, I'm going to ask the state to approach before we even get near addressing that issue in front of our jury. Okay? Ma'am, do you have any other questions for me at this time?
I do not.
All right. State, anything further?
No, sir.
Defense, anything further?
No, sir.
All right, we will see you all tomorrow morning at 9 a.m. The court will conduct its regular docket at 8:30. Thank you. We're off the record.
We'll watch this until the feed drops, which might be any second now. She's going to be escorted back into custody with the pink handcuffs and the belly chain, which is the only restraint that she has. She only has that while she's transported. During court, she is completely unrestrained, much like we say, I don't know, Brian Koberger up in Florida. I'm not aware of her having any sort of shock device. That was something that was raised at one point in the preliminaries, that especially when she was pro se, that she might wear some sort of shock device. But it looks like that's not the case here. I've got to. Well, once this is over, we're going to. I've got to reach out to Trial TV Live and just get some things ironed out for tomorrow. Just some technical stuff, so we can help each other a little bit with the stream, because I know they've had some issue on their side with the internet. I might have a fix for that. Let's see.
From Jules.
Jules, you can talk now out loud. How are you doing?
No.
It was great. It was great having you whisper to us from the jury box, but now you're full volume. What do you have for us?
Down on the left. Thank you. I got all discombobulated because I had to go pick up, that item.
Yeah, awesome. Did you get it?
I did, and it's good through the end of the year.
Wonderful. You're now. I can now announce that you're officially a reporter for Top Rank Media. Thank you very much.
Yes.
I appreciate the badge coming through from the courtroom for that.
Yes, and I appreciate you and thank you very much. That I'm officially on board. Yay!
We've used you unofficially for a long time, and now it's
I know,
great to have
but
you
that's
officially on the
okay.
team.
So that was pretty wild. Yeah, during the break and stuff, I'm totally lost. I have no idea where I am. They sent me out. Oh, now I guess I get to go out a different door now that I have a thing. I have to find Chris. I have no idea because my car is being used as the media mobile.
Yes, it is.
Anyways, it was really weird. I mean, like Judge Cranick is like, you know how I feel about Judge Carroll. I love Judge Carroll,
right?
But I have to tell you, Judge Cranick has kind of superseded Judge Carroll for me now. This man is so nice and stuff. And so when I called you, he was there. Like he was like, because I kept looking at my phone. I was going to get up, and I went to say to Mr. J, do I have time to go make a phone call or what? And he said, I don't know. He says, they were waiting on Sarah. So Judge Cranick heard me, and he's like, go ahead. We're not on the record. You can go ahead and do it now. So
It's like, you should ask him directly. Can I have some water in here? I get really thirsty. It sounds like he's easier to work with than the court officials, which are usually more strict.
Yeah. So he was like super cool. So anyway, we've got 8 women and 6 men.
How does it break down as far as the deliberating jurors, the first 6 on gender-wise?
Well, okay. All right. You're going to fire me the first.
That's all right. We'll ask that question later.
Okay. What do you call it? The way I couldn't get him in the way, because they were calling the numbers so fast,
right.
And then with the stand,
It was
so
like a speed bingo round. It was amazing how fast they were picking numbers, and we have both their juror numbers and their juror seat position. So we'll get a take for that. That's all right. We're super excited. Court's going to start tomorrow. I know you guys have to get there super early because if you thought it's a media circus now, it's going to be nuts tomorrow. It's going to be absolutely crazy. We need you there early.
what do you call it? Just an FYI. Remember when they were bringing certain in back in to speak to individually? Do you remember that?
Yes.
Okay. Do you remember the woman that was called back? She
Juror 13.
is
Oh no,
the DV victim that she will be testifying. Okay, she made it.
She's a deliberating jury. She was at one point. She was like nearly our final juror, and then they struck on back strikes almost everyone before her, so she was almost at the front of the line. Then.
Yeah.
But she is on the case. They must think that she's going to relate to Sarah or something. But
I don't know, but she's on there. So it's kind of crazy. But yeah, so out of the men, 2 are black, and then on the females, they're all white. Well, I think one may be Hispanic, but I'm not quite for sure.
Did we get that Jamaican guy with the great voice? Yes. Yes, he's on. He's probably an alternate, I think. Is he?
Yeah.
Yeah, he's an alternate.
Yeah, he's an alternate.
Okay.
But some of the ones that me and Joel were kind of surprised on which ones made it through and which ones didn't. But it was crazy.
Yeah.
But that's a rare thing. I hope you let your chat know that, you don't normally get to see that live.
Yeah.
You know what I'm saying?
And not to that extent. Even the times we have seen jury selection live, we haven't been a part of the sort of like the back and forth with the judge about the strikes. It's always sort of happened off on the side, and we hear the end results. This was a first for us to be, really have an open door right into the court. One of the reasons we love Florida, with being a sunshine state, we really do get a lot of access here, and we love that. Thank you also for giving us the additional view beyond what the camera can see. Now, let me ask you a question. Is this the same cameraman we had in the Maya trial? Do you know?
Yes, it is. It's Paul.
Okay. I will say,
Paul.
I recognize his close-ups.
Oh, well, wait a minute. Let me correct this. The camera guy in Maya, you're talking about inside the courtroom, or are you talking about the one that was doing outside for the interviews? Because there was 2.
I don't remember.
The tall black gentleman did the inside of the court, and Paul did outside in Maya's trial.
Yeah. Okay. I haven't met him either.
So to be clear, inside is Paul, not the guy that was inside for Maya.
All right.
But yeah.
All right, here we go. I'm stopping the feed there I just had to work that out with Trial TV Live. All right, tell Chris thank you. I'll be on the phone with him tonight a little bit to talk about
I'm on speaker so he can hear you.
Chris, I'm going to talk to you a little bit about some options about possibly dual streaming direct from the live view to your channel if you want, because I know there were some hiccups. With stuff, but we'll do that. We'll take that off the air. So.
Do that off there. So in any case, that's basically it. That's it. It was a long day. I'm so glad the day is over.
Yeah.
So they're sworn in. So first thing in the morning is opening statements, and then boom, we go into testimony, and we're done. I mean, we're going like full force.
It's going to be awesome. Jules, thank you so much. I'll let you get some rest because it's going to be a crazy day tomorrow, and I know it has an early start.
I wanted to leave, but someone from the defense team told me not to. Go figure that. And said, awesome. No, I don't think you want to leave. And I was like, right. They're like, just stick around.
The way the judge was handling those questions and just methodically, just working through it, no breaks, no pause, no... all right, let's stretch. It looked like he wanted to have openings, and then at the end, he looked at the clock, and it didn't add up. But he did get some of the instructions read, so he is trying to make up for some of the lost time of having that, the hurricane delay. So
exactly. And anyway, love you, Scott. My best to Mrs. R.A. and the family and the entire chat, and we'll talk tomorrow.
All right. I'll call Chris and Aaron in a bit too as well.
Oh, what are you doing? What are you doing? But you're streaming. You're still streaming. What's this?
Tomorrow we're going to be on Sarah Boone. We're following Sarah Boone gavel to gavel.
Okay, then I'll call you on break.
But I'm going to be in South Carolina cutting trees with a chainsaw. Just
Jesus,
tomorrow.
Please be careful.
Yeah, I'm not felling trees. I'm cutting branches that are on the ground. I'm not going to be felling any trees. I'm not going to be on the roof none of that.
All right, so then I don't call in tomorrow, is what you're saying.
Probably tomorrow you might get a pass. I know you've got a couple other people that might want you to call them, so please, do share to all those people. But we'll be following it, and I'll be here on Monday going forward with the trial.
Okay, and I'll be live tweeting from the courtroom as well. So
excellent. Jules, thank you so much.
Right.
You've deserved
You're
a long
welcome.
break. Thank you.
I don't know that I could sleep in that. Good night.
I'll send you some Southern Febreze.
Yeah, I need it.
Thank
Bye-bye.
you. We'll see you. Bye.
Bye.
All right. Love Jules. She's amazing. All right. Let's see. That's it. That's it for tonight. We're gonna pick up with this case tomorrow. Please, we'd love it if you just found the channel today. We'd love it if you click the subscribe button and come back and join us tomorrow and through the rest of this trial as well. We've gone to I would say a great expense and effort to get to bring this to you live from court with the equipment and personnel in place, and hopefully we can get you what I've always strived to do, which is better audio and better video than you'll find anywhere else. That's our goal. And we have people and equipment in place to realize that. So tonight also we have a podcast on this channel. What's it about? Not court. It's called the Not Relevant Podcast. It's a lot of fun. It's sort of a break.
Good luck tomorrow.
Hey Donnie, how you doing?
Just do me a favor. Just don't do anything I wouldn't do.
Oh, that leaves my options open. Thank you, my friend.
Bye-bye.
All right, bye, Donnie. Always the comedian. We have a podcast tonight called the Not Relevant Podcast. My good friend and one of our mods here, Thomas, his name is Weather Watch on the channel, but Thomas and I will be hosting a podcast right here. So if you'd like to see us in a different environment, sort of laid back, kicked back, that would be. Is this Donnie again?
Call from
AWOL.
AWOL. Sorry, I thought you were Donnie. Your number was actually fairly similar to his.
Oh no, they took my identity again?
It's Donnie. You never can trust him.
Nah, this has nothing to do with trial. I just wanted to call you. This will be quick. Human to human, I really appreciate what you're doing. Mm-hmm. You are a good human being. You're a good person. I hope you have all the blessings that you deserved. From the outside looking in, you always smile. Right?
Well, I'm happy.
And it's a beautiful thing.
I'm happy. I have to admit, I love what I do. This is a dream come true. It's something I never imagined I would be able to do full time. I never imagined I would be on camera. There was a point where I swore I'd never be on a video ever. Like I'd hide from cameramen at weddings.
Yeah, you said that. You only did it one time.
And here we are. But I absolutely love it. And it's not just that I love court and I love the law and I like the legal process and the chess match and the drama and everything else. I like connecting with people, and I love the community that I've found here, and it's amazing. And you're part of that, AWOL. So thank you.
100%. And regardless if the channel goes away or not, I hope you continue to receive all the blessings that you deserve, because I think you do deserve them.
I hope it doesn't go away either, but I appreciate the sentiment. So thank you.
Yeah, I'm not saying that. I'm just saying, regardless of the matter, you deserve all the blessings in the world.
I appreciate the kind words. I am human like all of the rest of you, and of course, I'm not going to show my down moments, my off moments on camera. So you see the best of me. Those that are a little closer know that there's more to me, and I'm still a work in progress. But
and that
thank you
I
very
know.
much.
Yes, sir. Yeah. So that's all I wanted to say. So be safe out there this weekend.
Will do.
And I also say watch your little piggies when you got that chainsaw going.
Yeah, I have to. There's a class they want me to to watch tonight and get a certificate to make sure I follow the training. I've been using a chainsaw for years. It's one of the first tools I bought when I moved to North Carolina because nature is trained to kill you here. And it does it by slowly growing around you and enveloping you. So I've been cutting things for years with chainsaws. But we'll do that. Thank you very much. I appreciate that, Awol.
Okay, man. Be safe, man. We'll see you.
We'll see you. Bye.
Yes, sir. Bye.
All right. We do have a podcast tonight. We'd love it if you join us. It is 8 o'clock. We'll have a thumbnail up with some people in there talking fairly soon. I'm going to run to Lowe's and buy some gloves, a square nose shovel, a replacement chainsaw blade, and I think there's something else I needed, but I can't remember. So I've got to go do that. But we'll be back in time for the podcast. You don't want to miss it. Hope you all can join us there. It would be great. We've waited for Sarah Boone's trial for a long time. She's waited for a long time. I'm so glad it's here for her because the one thing I haven't liked about her trial, although it's been humorous to see the way she handles some things and the way she views the situation, it hasn't been funny how long she's been sitting in jail, waiting for her day in court. So I'm excited for her that is here. We're probably looking forward to different outcomes, but we're going to play it out here, gavel to gavel, as that happens. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. Until we go live again, it will be tomorrow morning with Sarah Boone, opening statements at 9 a.m. Eastern Time, other than the podcast. So we're going to go live with the podcast, but then court's going to begin tomorrow morning. So please join us for both. That would be great. I'm a little bit tired. I'm a little bit giddy. Love that this is all working out. So thank you all. Thanks for being here. You guys be good to each other. We'll see you in a bit. Bye. 8 o'clock Eastern.